Page 5. Page 6. Page 7. Page 8. Page 9. Page 10. Page 11. 12. Yes, Honorable Kisilinyako, page 11.
Mr. Speaker, page 11. Question number 415. Ahima Kokobeng. There is no G after Kokobeng. So we should delete the G. This is a minor observation. Thank you, Mr. Speaker.
I think what was captured in the question have G. Is a member who asked the question present? What's the correct position? Honorable Kinsrinyako, take note.
Thank you, Mr. Speaker.
Page 12. Page 13. Page 14. Page 15. Page 16. Page 17. Page 18. Page 19. Page 20. Page 21. Page 22 and 23. Honourable members, in the absence of any correction, yes.
Mr. Speaker, thank you very much. It's not a correction, but on page 15, in this era of technology, is it not better to get the signature of the speaker and the clerk imprinted on this document instead of leaving it like this? Is it not better to change? Since 1992, we have always left it blank. But if I were to take this document and you have the two names there, because somebody one day, even though we know it's authentic, but somebody will say it's not authentic. Today we have digital signatures, so they can, instead of leaving it blank, you can always imprint it upon, and it will appear the same way. I was asking whether that is possible, Mr. Speaker.
Well, it can be possible, but there may be a problem when the speaker and the clerk are not around.
Mr. Speaker, as long as it's the speaker and the clerk who are, they don't need to physically be present to sign. They don't need to.
Well,
if you want to use the two of them as a signature.
If there are somebody like me who wouldn't want a signature to appear and a document that I have not perused, that will still be that problem.
but Mr. Speaker, then why leave the names? What is the use of, what is the value of the names under there? What is it for?
You know, when it comes to interpretation, using a name and a signature, the weight that is attached to a signature is not the same attached to just the name. But this is a matter that we can consider. Honourable members, in the absence of any correction, the vote and proceedings of Thursday, 6th November 2025 is hereby adopted as the true record of proceedings. Honourable members, we have two official reports of 30th October 2025 and 31st October 2025 for your quick corrections. We shall start with the official report of 30th October 2025. Honourable members, the official report of 30th October 2025 is before you for your corrections. Other members, any correction? Honourable members, in the absence of any correction, the official report of Thursday, 30th October 2025 is hereby adopted as the true record of proceedings. Now, the official report of 31st October 2025 is for your corrections. Honourable members, any correction? Honourable members, in the absence of any correction, the official report of 31st October 2025 is hereby adopted as the true record of proceedings. Honourable members, the next item in the order paper is item numbered 6, presentation of the business statement for the 4th week. Chairman of the committee, will you please present the business statement?
Thank you, Mr. Speaker. Your committee met yesterday, Thursday, 6 November 2025, and arranged the business of the House for the 4th week, which ends on Friday, 14 November 2025. As usual, formal communications may be made by the Right Honourable Speaker. We have 28 questions to the Minister for Lands and Natural Resources, Minister for Labour, Jobs and Employment, Minister for Roads and Highways, Minister for Food and Agriculture, and Minister for Tourism, Culture and Creative Arts. 1 is urgent and 27 are oral. Statements may be made pursuant to Order 91-2 by Ministers of State on government policies, and also honourable members may also make statements pursuant to Order 93. Bills, papers and reports in accordance with Order 159 and 160 may also be laid, and pursuant to Order 97, papers may also be laid during the week, and reports from committees may also be presented to the House for consideration. Motions may be debated and consequential resolutions taken. And again, we attach a list of pending referrals before the committee for the attention of the House as part of the effort to remind the respective committees to expedite work on the referrals and report to the House. A total of 300 referrals have been made to 23 committees for consideration and to report to the House. We urge colleagues to try and work on the referrals. Mr. Speaker, on Thursday, 13th November 2025, the Minister responsible for Finance, on the authority of the President of the Republic, will present to this Honourable House the budget statement and economic policy of the Government of Ghana for the year ending 31st December 2026 in accordance with Article 179 of the Constitution. The Business Committee therefore urges the honourable members to take note and be present in the House on the said date. Submission of budget estimates. The Speaker, the Business Committee urges the Ministry of Finance, other ministries and independent constitutional bodies to submit estimates to the House on time for consideration and approval. Post-budget workshop. Mr. Speaker, in view of the presentation of the budget statement and economic policy of government, a post-budget workshop will be scheduled for the participation of all members of Parliament. The venue and time will be communicated in due course. Mr. Speaker, in accordance with Order 2162 and subject to Order 67, committee submits to the House the order in which business of the House shall be taken during the week. Thank you.
Thank you very much, Chairman of the Business Committee. Honourable members, the Business Committee, led by the Chairman, has presented the business statement, and it is now for your comment. Yes, Honorable Dominic Nitiwul.
Mr. Speaker, thank you very much. Mr. Speaker, I noticed from page 2 of the business statement, paragraph 3, that the chairman makes some referrals at committees, or he points out that there's some referrals at committees and that the list is attached. So I actually went to look at the list, and it is on page 1 of 22, it's page 1 to 22. I've gone through each and every one of them, and I want to thank you for this. It's very, very good. But missing is the referral to the committee on the appointments, or the appointments committee. But because I thought Mr. Speaker had done some referral to the appointment committee, I've looked at it and it's not there. I want to find out from you when that exercise will be done. When is the referral going to be taken by the committee? Because it's as important as any other, if not very, very important. So I want to find out from the chairman why he's not here and when that will be done. When will the referral be taken? Thank you, Mr. Speaker. That of the Chief Justice. That's what I'm talking about. Thank you, Mr. Speaker.
Yes. No member, you have the floor.
Mr. Speaker, I noticed that the Minister for Interior spoke at length on the post-election violence report. Mr. Speaker, we would want to find out when it will be brought to the House to ascertain the fate of Nakoyo, and as to why his own colleague threw him under the bus. Mr. Speaker.
Honourable member, have you taken a look at the business statement carefully, indicating that report may be presented? Honourable member, you pretend as if you've not heard me. Have you taken a look at the business statement indicating that reports may be presented? Yes, Alaji.
Thank you very much, Right Honourable Speaker. Mr. Speaker, for some time now, members in this House have put on complaints to the majority leader and leader of government business about the office air conditions. Mr. Speaker, up to now, we have not seen any action from the leader of government business. And some of these air conditioning not working has contributed for members not coming to Parliament. But if you come to Parliament and you don't have anywhere to sit before you come to the chamber, it's difficult for members of Parliament. So I'm pleading to the leader of government business to, as a matter of agency, to look into it so we'll see how best the air condition will be fixed for members in the shortest possible time. Thank you very much, Mr. Speaker.
Yes, Honourable Kinsley Nyako.
Mr. Speaker, thanks for indulging me. Mr. Speaker, related to the non-functioning of the air conditions in our office, I would like to suggest, if possible, because Mr. Speaker, we come to Parliament at times early in the morning. You cannot sit in your office, you cannot hold meetings there because the environment is so hot. You are compelled to go to the library. The library opens at 9 and closes at
Honourable
5
Kinsley
p.m.
Nyako, is that not repetitive of what the Honourable member has just said?
No. I'm saying that we visited the library, and the library starts at 9 and closes at 5. So if it's possible, that because of the inconvenience in offices, if the library time can be expanded, so that instead of 5 p.m., for example, they can close around 8 or 9, so that some of us can also go there and study, because 24-hour economy, the library can even do 24 hours. So I'm just suggesting to my revered leader that for the sake of some of us who don't have the luxury of reading in our offices, to make use of the library. This is a request. My other issue has to do with the lift, which is not functioning properly and it's not helping us. Because at times, those of us on the 11th floor, if the lift is not working, you have to walk and look at the level. I mean, it is so troubling. My last issue has to do with the microphones in the committee rooms. At times, it's so embarrassing that you are holding meeting in the rooms and you struggle to even speak into the microphone. So I think as a matter of urgency, we should get them fixed. It even affects our image. You have guests and they're not functioning, they're not working, and the image out there, Mr. Speaker, is not the best. So I want to put this before the House. Roxanne,
thank you very much.
Let me raise my issues.
Honorable Sanja Nanja.
What is that?
Oh, are you done?
Let me raise my issues.
Honorable Kinsilinyako, are you done? Address the chair.
Respect, I'm done.
Thank you.
Thank you.
Honorable Sanja Nanja.
Thank you, Mr. Speaker. The question standing in my name on Wednesday, question number 454. I want to draw the Business Committee's attention that the question has already been asked on the 29th of last month. So, on the 29th of last month, and it has been repeated here, if they could just expunge it.
Very well. Yes, Honorable Anodon Prayer.
Thank you, Speaker. Speaker, let me commend the Leader of the House for the presentation. Speaker, we are told the Finance Minister is scheduled to be in the House on Thursday. And as has been the practice of this House, Speaker, leadership has a role to play in preparing the House, so to speak, to be ready to receive one of our own, the Minister. I don't need to elucidate on details. I humbly want to suggest to my good friend, the Chief Whip, and the Leader of the House, I don't think it will be out of place for us to have a committee of the whole so that we can engage appropriately before the minister comes. Speaker, I've seen the advertised questions, 28 questions. Speaker, I'm old enough in this House to know average number of questions that we often take in a typical day. I concede that because of the budget presentation on Thursday, we have limited number of days to deal with questions. But, Majority Leader, as of the last check at the table office, we have an outstanding some 320 plus questions. It's worrying. I don't need to belabor the point, the essence of questions. We know is a critical tool at the disposal of members to elicit response as part of our oversight. I also looked at a number of the questions. If we are not careful, we will be going much. There are lots of questions that are not being answered. Even today, Majority Leader, if I have your attention, even today, Majority Leader informed us at conclave, questions slated for today cannot be answered because the minister is not available. That's what he said. Even though he has failed to communicate officially, I wouldn't want to go into that. But the grammar part of my point is that we must get innovative to get these questions dispensed of.
Yes, but honourable member, in all fairness, he told us why the minister cannot be available. He said so to us at conclave.
Speaker, I have always been fair, but I'm saying that the minister has not written. At least that has been the practice. It cannot just be by mere word of the mouth.
No, what you said is that Majority Leader didn't tell you why the minister is not here.
Speaker,
and I'm saying that in all fairness, he said so and I have heard him. That
Speaker,
is quite different from writing formally.
Speaker, I wouldn't want to do this with you. What I said was, even though he told us at conclave, the minister has not written officially. What I'm saying is different from what you're saying.
Okay, then in that case, you are right.
Yes, Speaker, I'm right. So the questions are hanging, over 300 questions, and they are still hanging. This is the Parliament of Ghana. We demand answers. 300 questions still hanging in the balance. And we are being told that even those that have been advertised, Speaker, you see, that is the crux of the matter. Even the questions that have been advertised on the order paper, we are not taking them. It's a big challenge. And how would the public see us? Besides the point, we have businesses that are advertised. I was nudging the Majority Leader. Businesses that are advertised on the order paper, and they remain there, mute. We don't take them. For instance, the Ghana Scholarship Authority bill, we are aware there's an engagement going on that we shouldn't advertise it. The table of it should be liaising with the Majority Leader. We can't be putting businesses, advertising businesses on the...
That is also not correct. Because we took few clauses and we intend finishing same today. We took few clauses yesterday and we intend doing the rest of the clauses today.
Speaker, fair enough. So, I won't belabor the point. Majority Leader, I want to plead with you. 300 questions is not a joke. And you can check at the table of it. But Roxanne, evidence. Check at the table of it. Members file these questions on reasonable grounds. And they demand answers. And all we hear is that the minister is not here, the minister is not available, and these questions are still pending. So I plead. When the budget is presented, we go, this is the cycle, we go for post-budget workshop. When we come back, we are going to start taking motions. The motions will be taken all the days. Hence, these questions will suffer. 320. When are we going to take these questions? So Majority Leader, you are a fine gentleman, but the way sometimes you trivialize some of these things, questions, we cannot compromise. We on the side.
Yes, but as a member of the business committee, having regard to the volume of the questions, you can suggest it at the business committee to increase the number of questions that are supposed to be taken a day.
So I'm happy you made this suggestion. And that also brings another matter in wake.
Yes, but you are part of the business committee. So you are supposed to be part of the document being presented by the chairman of the committee.
The records will reflect that I've been on leave. I've been on leave for some days. So I wasn't at the business committee. But Speaker,
so get in touch with your colleagues and let's do the
needful. Even if there is always afterthought. If I'm not able to raise it at the business committee, nothing bars me from raising it on the floor. Yes, so Speaker, it's a fact. And so another matter that is pending is that the table office is being told by the Majority Leader that they should seek the availability of the minister before questions are programmed. That is wrong against our practice. You can't do that. We can't do that. The table office goes through a certain motion, and they give notice to the ministers. The ministers, where they cannot appear, they must write formally to us. So we have over 300 questions. We are not answering the questions. All of them are being deferred. Those that are even being advertised on the other paper, we can't take them. And we are told
you just told us that you took leave. So would it be fair to program a minister to come and answer a question whilst on leave?
Speaker, I think that I will not take this matter beyond a certain level. And I'm not being a litigant. So I'm saying that I have sat there. They were here. In fact, the majority leader, I can point his seat to you. He sat around this area. And he, my friend, Roxon, was there. And then we had a black one here. And then the speaker himself was also here. No, speaker was here. Speaker, sit down. Speaker, the telepathy and the chemistry. You see, Speaker, the gun has now been turned on you. And the majority
I don't want you to remind me of my opposition days.
Why is he shielding the ministers?
I'm saying don't remind me of my opposition
why
days.
Is the majority leader shielding our ministers? You should allow them to come in. You said you have achieved so much within 1 year. And yet, seriously, I want to plead with the majority leader. I am available for suggestions. You recall, majority leader, you recall all the outstanding referrals. I came to you and suggested to you that let's advertise these referrals. And now there are about 300 of them. And then we put pressure on the committee leadership for them to work. I am a man of peace. We want to work. We want to help majority leader
thank you very much.
to prosecute government business.
Yeah.
But he himself is not helping himself.
Thank you.
He's not helping himself.
Thank you.
So the questions, we want a good response. I should withdraw each one.
I will call on the chairman of the business committee.
Is inadvertent
to respond to the issues raised.
So I haven't finished. You should wait. I haven't finished.
Oh, I thought you said I should call on him to come and respond.
I haven't finished.
Oh, honorable and not on prayer.
But just please sit down. I haven't finished. You won't allow me to speak.
Yes, majority leader and chairman of the business committee.
Right, Honorable Speaker. On listed referrals, the appointment committee indeed has a referral, specifically the consideration of the nomination of a new Chief Justice. The indication I have from the chairman of the committee is that on Monday the committee will meet this Monday, the committee will meet to consider the nomination of the new Chief Justice by the President. So I think that it was an oversight that table office did not add that to the list of referrals. Office air conditioners. Yes, some air conditioners are not working. There's a procurement process to procure the replacement of some essential parts that will enable all the air conditioners in those offices to function effectively. I appreciate that in the interim, some level of inconvenience is being suffered by members whose air conditioners are not working. And so I want to assure you that we'll expedite the procurement process so that they can expeditiously address that problem. In the interim, I think we will take on board your proposal for extending the closing time of the library. That's a matter that I will take up with the clerk of Parliament, if they can extend the closing time of the library. And I also heard one of our colleagues for Nalerugu raise the issue of air conditioners being the reason for absenteeism. I have been in this house long enough. What you see now as offices are actually recent additions to this parliament. I'm sure Nitiwo will recall that in the days when he was a whip, we didn't have offices. We didn't have offices. And yet we came to this house and we sat in this chamber and we prosecuted our constituents' business and government business. So I do agree with you that we need to urgently fix the air conditioners, but the challenges with your air conditioners cannot be grounds for not showing up. If we publicly indicate that when air conditioners in our offices are not working, we should stay away from our work. And our work, in addition to sitting in the office, is actually being in this chamber and prosecuting our constituents' business and government business. If you give that indication to the public, you are essentially telling civil servants that when the air conditioners in their offices are also not functioning, they should also not go to work and provide services to the public. So we can raise the issues, but the way that we raise the issues send very, very wrong signals out there. And I just thought that we need to be measured in the way that we dramatize Friday business statement time. I understand the drama and the politics behind Friday business statement time, but let's be careful what we say and how people will interpret it out there. Microphones in committee rooms. It is also not true that the microphones are spoiled. Some microphones, and I've observed that some of the microphones, the part where you press so that it will give you an indication to speak, people often don't know how to press it, and some of them are a bit defective now. So you need to press so hard sometimes before you are given the indication to go ahead and speak. So I have experienced that also in a number of committee rooms. But a lot of the microphones are all working. They are all working. So you can't say that microphones are not working and etc. When you keep making those statements, I can understand that the objective might just be to create an impression that things are not working. But things are working. As we speak, you are on live television. A year ago, were you on live television anytime that you were sitting in this chamber? So things are working. There are improvements. Let's acknowledge the improvements. Let's acknowledge that things have gotten better, and then we can move on. I also noted that a colleague raised the issue of question number 454, which is a question that has been asked already but has been repeated. So the table office should take note that question number 454 has been asked and repeated. I also agree that we should consider having the committee of the whole meeting on Tuesday in preparation for the budget presentation on Thursday. And also the issue of questions. I think that we need to put the issue of questions in proper perspective. Our own standing orders are very clear on questions. Order 77 says that 77.2, question time shall ordinarily not exceed 1 hour. Question time shall ordinarily not exceed 1 hour, except that the speaker may permit a question after the expiration of the time stated. So the clerks in the table office have to be measured in terms of the number of questions that can be asked in any given day in order to fit into the 1 hour time that the standing orders dictate must be the time allocated for question time. And so that could influence the number of questions that can be asked any given day. But even then, the records do not bear out what the minority chief whip indicated, because yesterday alone, I think we had Yesterday alone, we had over 16 questions asked. Yesterday, when we came to this chamber, 16 questions were asked yesterday. 16. And if you go to the previous, votes and proceedings, you will see that averagely, unless a minister doesn't show up for some good reason, averagely, we have about 16 questions asked. And we always exceed the time allocated by our own standing orders for asking questions. And when we brought in the question of making sure that the table office reached out to ministers directly when scheduling questions, is to make sure that the ministers are aware that they have been scheduled. Because at the business committee meeting, you were not there, but your colleagues were there. I don't know if were you there that day? You were there. So if you were there, you will understand the context in which the issue was raised. Because there was complaint that ministers don't show up to answer questions. And you raised it during business statement time. So at business committee meeting, I raised the issue with the clerks that there is complaint in the chamber that ministers don't show up to answer questions. Do you normally ensure that the minister is aware that they have been scheduled to answer questions on those given dates? I asked the clerk, and the clerk said, oh, there is a scheduled officer that I deal with in the ministry. So I said, no. The scheduled officer may also not be communicating to the minister. So if you do that, and the minister is not aware, he will not show up. And if he doesn't show up, members will raise the issue of ministers not attending to Parliament to answer questions. So henceforth, make sure that when you are scheduling a minister, you actually ensure the minister is aware by calling the minister, because they have the numbers of the ministers. How the scheduled officers are not the ones that Parliament is calling upon to come and answer questions. So if you call a scheduled officer and you don't call the minister, and you come and complain that the minister has not shown up to answer a question, is he the one that you informed about the question? So the issue is, and I told her that if you can't reach a minister, my job as leader of government business is to make sure that I help you to reach that minister. Is that not what I said at the meeting? So if you can't reach a minister, you can reach me, let me know, I will make sure I reach that minister. So there and then, I said, let's try it today. So in the presence of all members of the committee, we called the ministers one after the other. Some actually did not know that we had scheduled them to answer questions. And some indicated that the date that we had scheduled, they were unavailable. So we shifted and then, rescheduled those who were unavailable on the dates. And that became her example. And since then, I always ask her, and she indicates that she is able to reach the ministers. And I indicated at conclave that the minister may not be able to attend today. It doesn't mean that the question may not be asked today, because the minister has sent his deputy, and so I'll ask for permission from the speaker so that the deputy will answer the question. Mr. Speaker, this issue about conferring with ministers in order to schedule their questions being misrepresented, that I am shielding ministers, is clearly wrong. Mr. Speaker, again, let us get back to Order 77. Order 77.3 says that a minister, a member, or the head of an independent constitutional body shall not take more than 3 weeks, upon receipt of a question from the House to respond to the question. So a minister can tell you that he will answer the question in the 2nd week. He can also tell you that he will answer the question in the 3rd week. But he cannot take more than 3 weeks. So the right of ministers within the 3 weeks to determine the schedule is also protected by the standing orders. So you can't say that he must come the 1st week. You cannot, because your own rules tell him that he has 3 weeks to answer the question. It means that he has 3 weeks to send his officers. So if you ask the minister a question,
to find out from the minister why the clinic at Bador in Boku Central Constituency has not been roofed. He needs to send somebody to the clinic to confirm that indeed the clinic has not been roofed, and now find out from the district health officer why the clinic has not been roofed. The district health officer has to send him a written report so that when he comes to this house, he can give you an accurate response. That is why they are given the 3 weeks to gather the information to be able to respond to you. It is only in exceptional cases that you can ask an urgent question, because it is indeed an urgent matter, and we compel them to come and answer it as an urgent question. But any ordinary question that you ask of a minister, that minister has 3 weeks to prepare and come and answer that question, and that is not negotiable because it is in our rules. It is not the ministers who enacted the rules. So nobody is shielding any minister. One, I want to make sure that the ministers are in the chamber to answer your questions, and so they must be aware that they have indeed been slated to come and answer questions. And they also have a right to negotiate and then use the 3 weeks time window that you have given them in your own rules. Mr. Speaker, I think I have responded to all the issues raised by members. Yeah, the elevator is being worked on. There are several elevators, so let's also be careful when we create the impression that the elevator is full. There are 6 elevators, I think. 6 elevators. We have 6 elevators. So if one elevator is faulty, you have 5 extra elevators. If 2 are faulty, you have 4 extra elevators. And this is not the first time an elevator is developing problems in this parliament. So don't create the impression that the infrastructure has suddenly broken down. If anything at all, you know that some aspects of the infrastructure have been enhanced. So the elevators are being fixed. Whenever there's a breakdown, the engineers are called upon to come and then fix them. But I also think that we need to monitor the use of the elevators. Some elevators have been preserved for members of parliament. Then other elevators also made available to the general public visiting us. And we also observe that you allow visitors to use the elevators reserved for members of parliament. When that happens, and then your assistants, they are always in the elevators going up and down, and then the wear and tear. So please urge your assistants in the offices to keep to the public elevators, whilst the elevators reserved for the members of parliament are reserved for the members of parliament. If the wear and tear on those elevators are minimized, you will have the elevators serving their purposes for long periods before they are serviced, in order for the elevators to be fully functional. So I think also that we need to pay attention to the way that we use those facilities. Mr. Speaker, I think I have answered all the questions asked by members on the business statement that I have presented. Thank you, Mr. Speaker.
Yes, Honorable
Speaker,
Honorable Minority Whip.
Speaker, I thank the leader for his response. And Speaker, let me say for the records, my earlier submission was not to interpret 77.3 in my own understanding. In fact, 77.3 is clear. But I want to put on record that the respected majority leader should check from the table office the outstanding questions vis-a-vis the ministries who have been communicated to, and look at the time elapsed, whether they don't stand in default of the 3 weeks provision. I also spoke in a certain context that when the budget is presented and we go for post-budget hearing, the rest of it is motions for the approval of estimate, and we cannot practically take questions.
So my suggestion to the majority leader is that in the face of the circumstance we find ourselves, where budget is here, we are going to be taking motion, over 50 motions, we have to get innovative and make sure that these questions are dispensed of. I hope he gets it clear. And I'm not out there to create any mischief or unnecessary attention. No, this is the Parliament of Ghana. 300 questions, Mr. Zuga, is quite a lot. And we have to look at how, as leadership, we can find a way to get these questions dealt with. I thank you, Speaker.
Thank you very much. On that note, I have a suggestion to the leaders. If we can suggest to members that during the time of supplementary question, we would avoid argument, a lot of comment before asking the supplementary question, it will help us to deal with so many questions within a day. Because when it comes to supplementary question, how many people do we give the opportunity to ask supplementary question? So if all those things can be ironed out, within a day, we can do a lot in terms of questions and within the 1 hour. Yes, Majority Leader.
Mr. Speaker, everywhere in the world, most parliaments, and I raised that issue at business committee meeting, and again, the impression was being created that I'm trying to silence MPs, but that's not the case. In most jurisdictions, even the number of questions that a member of parliament can ask in a sitting or a meeting is clearly known. So, Mr. Speaker, in this parliament, people ask all sorts of questions. All sorts of questions. And they ask as many questions as they want. Mr. Speaker, Mr. Speaker, Mr. Speaker, Mr. Speaker, last week, a minister was summoned to this house to answer a question about how many shrines are in this country. How many shrines are in this country? Last week, a minister was summoned to this house to answer a question, how many shrines are in this country? And the minister came and answered the question, how many shrines are in this country? Mr. Speaker, our own standing orders say that question time is 1 hour. Please go and take the video clips of the sitting of this house and ask yourself, do we ourselves as members of parliament in this chamber, do we keep to our own rules? The rules say 1 hour. Do we keep to that rule? So some of the questions you ask, we refer them to the minister. The table office is struggling to schedule the questions and trying to fit it within that 1 hour average. And that is why you see that they can't schedule all the questions. So let's also be mindful. And then also, you ask questions in order to elicit information about your constituency. Some of them, written answers can be provided. So there are, when you ask how innovative we can be as innovative as asking questions that just require written responses so that you have the information to share with your constituents. But if you want to ask the questions in the chamber and have it answered, and then sometimes we are begging you to be circumspect in terms of the number of follow-up questions so that a lot more questions can be asked, people will say no. So if we start insisting on the rules, I'm sure even the 300, we won't be able to accommodate them. And we can also agree that even as we consider budget, we will still try and then accommodate a certain number of questions every day that we come to sit. So, Mr. Speaker, I think the issue of questions is a matter that all of us must work on in order to
to address that challenge. But I can assure you that I have no intention to shield any minister. I can assure you of that. I also think that we should, manage our time well in this chamber in order to have the best in terms of output. And, let's know how we do the follow-up questions, and then we can ask many more questions every day. Thank you, Mr. Speaker.
Yes, Honorable Minority Leader.
Mr. Speaker, the chair of the Business Committee, in presenting the business statement, had the occasion to answer a question regarding a referral to the Appointments Committee. He indicated that the Appointment Committee has programmed the acting Chief Justice, my Lord Bafuboni, for vetting on Monday, the 10th of November. Mr. Speaker, we are here to approve the Business Committee's report as a House. And the rule allows us to amend, reject, modify the report that is presented to us. It is my contention that in view of precedents of this House, in respect of matters involving the rule of sub judice, this House cannot be invited to accept the vetting of the nominee for the office of Chief Justice, when indeed there are pending constitutional matters before the Supreme Court of this Republic and before the ECOWAS Court of Justice. Mr. Speaker, just for the avoidance of doubt and to lay a proper foundation for the submission I heretofore make, I shall rely on the official report of this House dated the 5th of March 2025. I will start from column 140 and read portions of column 142. Quote, Mr. Ayariga, Mr. Speaker, that is the point I'm making. The point I'm making is that there are two grounds on which I'm raising the objection. The first ground is that under our constitution, we must not interfere with the work of the judiciary. So if the judiciary is already seized with a matter, Parliament should not also take up that same matter and refer to it as Human Rights Committee. Parliament would be interfering with the work of the judiciary. Under the Constitution, we owe the judiciary a duty not to interfere with their work. And my argument is that we taking up the matter and referring it to our Human Rights Committee to also inquire into what would be interfering with the work of the judiciary. That is my first argument.
I recognize the Chief Whip.
Very well, Mr. Speaker.
For some time.
You may recognize him.
Speaker, may I humbly draw your attention to Order 71, Rule 1, 2, and 3. Speaker, the business before the House is the presentation of the business statement comments arising therefrom. Mr. Speaker, the minority leader on his feet is not addressing matters arising out of the business statement. Please, 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 please. Please, 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 please. Please.
Honorable Deputy Whip, are you on point of order against point of order? Point of order against point of order?
Mr. Speaker, Mr. Speaker, Mr. Speaker, I have not yielded. I have not yielded. Mr. Speaker, these are very serious matters. The minority leader, instead of speaking to matters arising out of the business statement read, he is seeking to bring in a matter that is before the court, and to seek to say that Parliament by that process is injuncted from performing its constitutional rights, and is referring to a matter that arose some time ago from the Hansard. In any case, the courts have decided. In me, I was in court. In Dapia Mekpon versus Attorney General, when I sought to enjoin this Parliament from vetting ministers nominated by the President at the time, the Supreme Court told me that I cannot enjoin this Parliament from performing its constitutional rights and functions. Additionally, our own brother Asefua went to court. The court told him, Asefua versus Attorney General, that this Parliament cannot be injuncted from performing its constitutional rights. So the matter is settled. So the minority leader cannot seek to rehash a matter that's already been settled by the Supreme Court. He's wasting our time. So if Mr. Speaker, if the minority leader intends to raise an issue arising out of the business statement,
if you don't want to listen, others are mindful of listening.
It should do so. It should stop bringing in the vetting, the scheduled vetting of the CJ on Monday, because that one, it will happen. This house will perform its constitutional rights and duties. The Supreme Court has already settled that matter.
Majority will be brief.
A mere filing of a case. In other case, Mr. Speaker, the matter before the court is a certiorari application.
Majority whip, be brief.
It's a certiorari application.
Honorable Majority Whip, be brief.
Yes, Mr. Speaker, I'm being brief. But let us settle the matters on the law. The application before the court is a certiorari application. There is no injunction application before the court. It is an application of certiorari seeking the Parliament, the court should prevent Parliament from performing its constitutional rights. And that application will be heard at a definitive date. But in the meantime, the Supreme Court says Parliament must continue to perform its constitutional rights. So that matter, the minority leader shouldn't go there. It is settled. It is right. It is settled, and he knows.
Honorable members, I intend to give the floor to Minority Leader to conclude.
Mr. Speaker, I come to this chamber prepared and fortified. I don't make lame submissions. A member can preside to make statement ex cathedra. I would rely on authority, and that is what I seek to do, and I move on a ground of relevance. Mr. Speaker, I was on a path of quoting Mr. Ayariga. I'll continue. He continues, and my argument is that we are taking up the matter and referring it to our Human Rights Committee to inquire into. We'll be interfering with the work of the judiciary. That is my first argument. He continues at paragraph 1. He continues at 142. This is what he says. Even though ordinarily we will wait until the person is making a statement and we think the statement is going to prejudice the interests of parties, then we object. But here, I am saying that the very language of the motion should already prejudices what it is saying we should do and what it is saying we should not, apart from offending the Constitution. We say we should not interfere in the work of the judiciary. In moving it, there is no way that he will not say things that will not prejudice the interests of parties in substantive litigation. Why the hurry? End quote. That is Ayariga. Mr. Ayariga, the majority leader of the 9th Parliament, invited the Speaker to hold that because there was a Nana Boakye case at the Supreme Court. By the way, the government of his objection was the fact that Henry Nana Boakye had filed a constitutional matter at the Supreme Court. Therefore, my application should not be moved at all, which objection was sustained by the Speaker. Now let us hear the Speaker, what he said in his ruling. Quote, honorable members, the motion, private members motion number 16 at page 6 of today's order paper was scheduled to be moved today. Then he continues, the Speaker may, in particular case where it is quite obvious, refuse to admit a motion, especially when it is covered by a clear-cut case. For example, if you put forward a motion affecting a matter which is pending in court directly, and it was brought to the knowledge of Mr. Speaker, he is bound to draw attention to the fact that such a motion cannot be properly debated by the House and therefore cannot be accepted. But it does not follow that in every case where motion is accepted and listed, the Speaker has necessarily gone through the motion, deciding every issue of propriety involved in that motion. The Speaker continues in his ruling. Honorable members, regarding the motion at hand, I am reliably informed that at the time the Right Honorable Speaker admitted the motion, the fact of an action pending at the Supreme Court regarding the subject matter was not brought to his attention. Based on the above precedents, the House must take its hand off the motion and allow other organs of state. I repeat, the House must take its hands off the motion and allow other organs of state properly mandated under the 1992 Constitution of the Republic of Ghana, that is the judiciary, to deal with the matter. Accordingly, the motion and subsequent debate on it is stayed pending the determination of the matter by the Supreme Court. This was not a matter of injunction. It was not an injunction. Mr. Speaker, according to the majority leader, there is going to be vetting. And the chief whip attempted to arrogate the full powers of this House to himself, as if we are dealing with a one-man power, show of power in this country, by saying it will happen, it will happen. We are not into blows. We are here to argue law and for you to determine. So this kind of attack that it will happen. We argue for posterity. Democracy and practice is for posterity. So they should take it easy. Mr. Speaker, let me draw your attention to detailed provisions in our orders. First, Order 2172 on the sub judice rule, Order 103F and 123.1, and on the Speaker's control of the business of the House, guided by Order 2164. Mr. Speaker, none of these expressly contemplate the coexistence of an active constitutional dispute over legality of vacancy. The vetting that is being announced seeks to fail. We have a situation at hand. One is procedure under Order 217 that empowers the appointment committee to consider a nomination when existence of the vacancy itself is sub judice. Are we going to do that? That the appointment committee, knowing that there is a sub judice matter, will still proceed to consider the vetting, whereas the Constitution itself contemplates that the office of Chief Justice will never be vacant. That is why even when the woman was originally suspended, there was an acting Chief Justice. So there should be no hurry. Nobody should contemplate that Parliament is somewhat stopped. That seat is not vacant. However, proceeding to vet a new person to fill that office will be rendering the application of Justice Gertrude Esabato Konu otious. Mr. Speaker, the second is constitutional. We would be proceeding on the part that would amount to a legislative interference with judicial process, contrary to Article 1253 and 1272. Mr. Speaker, which vests judicial power exclusively in the courts and oblige all state organs to protect their independence and effectiveness. Mr. Speaker, we have under Order 20 of our rules, 24 provides the Speaker is the head of the institution of Parliament and presides over the sittings of Parliament. 4. The Speaker shall A. uphold the honor, dignity, and the sanctity of the House. Mr. Speaker, if you read this provision in conjunction or together with the relevant provisions that protect the independence of the Constitution, we are being called upon, therefore, Mr. Speaker, to ensure that Parliament is never seen as bringing any other state organ into disrepute. You sit there, Mr. Speaker, have a duty to uphold the honor, the dignity and sanctity of the House. If this whole Parliament, in view of its own precedents, not long ago, in March, when Afenyo Makin and Habib Idrisu and Vincent Assefa had an application, which application was to determine a governance and practice issue, the majority leader argued strenuously that indeed that matter has a constitutional arm, had a constitutional issue attached thereto. Therefore, I should be restrained from moving the motion. Mr. Speaker, that was his contention. Much as Mr. Speaker, much as I argued that the matter before the House had nothing to do with the court matter, because the House still ruled. By your very good self, Mr. Speaker, you presided. Mr. Speaker, you presided and told us that indeed, because the matter was before courts, we cannot take the motion. Mr. Speaker, let me refer to Eskime, the 5th edition, Eskime, the 26th edition, Eskime, paragraph 2011, I quote, "The House has resolved that no matter awaiting adjudication by a court of law should be brought before it." The matter, if the matter is awaiting adjudication, this House must stay its hands. That is the law. That is the practice. Mr. Speaker, how then will the majority leader, in coming with a business statement, invite us to accept as part of the business statement the vetting of the nominee on Monday the 10th of November, when he is aware that the ECOWAS court has scheduled the 18th of November for the ruling in the matter brought before it? What does this House want to hurry to? Why are we in a haste? To render the outcome of the case nugatory, otious, to deny the woman, the Chief Justice of the Republic, her right to occupy her office?
Minority Leader, Honorable Minority Leader, Honorable Minority Leader, kindly conclude.
Mr. Speaker, it is public knowledge that the learned Attorney General has so far even refused to file a defense in the matters at the Supreme Court. It was only last week that he filed a motion for leave to file for extension of time to file. Mr. Speaker, all these are happening in this country, a country of rule of law, and Parliament would want to shut its eyes on this. Mr. Speaker, in any event, the man empowered with the mandate to empanel the court is himself the very person who has been nominated. And so far, whereas he was in a hurry to empanel the court to hear the injunction applications, none has happened in any of the 6 cases. Mr. Speaker, there's a High Court matter where the Justice Tokonu challenged the warrant of a removal. The AG filed an application seeking constitutional interpretation. It's been weeks that my Lord Bafuboni, who alone has the power to empanel the court, has not empaneled the court. In fact, none of the cases involving my lady Tokonu, as well as our respected colleague Vincent Asefua, has received the blessing of the court for the purpose of hearing. Meanwhile, the time for hearing has long lapsed, with the AG not filing any process and now seeking the leave of the court belatedly for extension of time. Mr. Speaker, I dare submit that the man who is going to be nominated himself is conflicted. He is in conflict. How can you, who knows that office, the occupant, is being denied her human rights, and you are supposed to empanel, you are refusing to empanel, yet this House should bless you with the benefit of vetting. Mr. Speaker, the majority leader cannot invite us.
Honorable Minority Leader, I'm pleading with you to conclude.
No, I'm concluding. Mr. Speaker, these are preliminary matters. We have our own matter to deal with, but we want to bring it in the context of the Business Committee report and invite the Majority Leader to graciously withdraw that aspect of his submission to the effect that on Monday there's going to be vetting. We will not support a report, that business committee report, that has an aspect that says that there's going to be vetting. Mr. Speaker, in any event...
Honorable Minority Leader, do you have the business statement?
Mr. Speaker...
The business statement
Mr. Speaker,
report.
With respect, the business statement, when a member... Mr. Speaker, I've been a majority leader before. When the business statement is presented and questions are asked and inputs are made, and the majority leader and leader of government business, and for that matter the chair of the business committee, confirms certain provisions, it becomes part of the report. That is it. Yes. So, Mr. Speaker, don't take me to that part. Mr. Speaker, with respect, he has confirmed that there has been a program. So, Mr. Speaker, let's not belabor. It's a fact. We are saying that he should take that off. He should withdraw that bit so that the original component of the business committee's report remains without any vetting whatsoever on Monday. Mr. Speaker, in any event, we, the minority, as law-abiding as we are, filed a motion several days ago, and I've done several follow-ups. Mr. Speaker, our minority should not be taken for granted. It should never be taken for granted. We are encouraged at all times that we should be law-abiding, follow procedure, and we'll be vigilant in that process. So, Mr. Speaker, awaiting all of this, the majority leader cannot just announce to us that Justice Araba Esabato Konu's prayer does not matter. She is a Ghanaian who was appointed. She has submitted herself to all due process. Her rights must be respected. This parliament must, with the greatest respect, rely on its own precedent not long ago and allow the court to determine the matter. It should be our collective call on the acting Chief Justice to quickly empanel the court. It must be our collective voice to encourage the Attorney General to file a defense. It must be our collective voice to encourage the Attorney General to go to the ECOWAS court and file a defense, rather than we being threatened by the chief whip of the majority that vetting will happen with all his might. We are not dealing with might. That vetting will not happen. It will not happen. You must follow due process. Follow the law. Do the right thing. We, the minority, will not shut our mouth. You can follow due process. That's all. Mr. Speaker, I want to resume my seat by saying that my submission does not in any way seek a ruling from you. I am not seeking a ruling. I am rather seeking the indulgence of the majority leader, who knows the rules, to do the needful by withdrawing this aspect of the report that is going to be vetted. Mr. Speaker, we know how to move our case and we'll do the needful. But this one is not a motion bringing it up for you to make a ruling. No. Mr. Speaker, that said, I will rest my case and hear the majority leader.
Right, Honorable Speaker. I think it is important, first and foremost, that we are reminded at all times that we are not just speaking to ourselves, we are also speaking to a wider audience. And so I always make it a point, as much as I can, to speak directly to the wider audience by trying to break down things to a very basic level. When you break down things to a very basic level, sometimes people who think they know realize that they actually don't know, and then they will appreciate. Now, the Chief of Staff had issued some directives regarding some recruitments that happened after the NDC came into office. And somebody went to the Supreme Court to try and get the court to intervene and determine that that action of the Chief of Staff was unconstitutional, it was wrong, it was a violation of the rights of those individuals. Then the minority leader brought a motion to this House, urging this House to take some decisions regarding the action of the Chief of Staff. So I raised an objection on the grounds that because someone has already gone to court to vindicate the rights of the people who were dismissed, it will amount to interference in the work of the courts for this Parliament to also go into that matter. This Parliament was asked to act in a matter that was quasi-judicial. Quasi-judicial. Once a judicial process was already underway. And so I said, you will be interfering in the work of the courts if they have started a judicial process of determining the rights or otherwise of those dismissed. Then you also come to this Parliament and say we should also start another process of determining the rights or otherwise of the same people. That will interfere in the work of the judiciary, because their main responsibility constitutionally is to vindicate rights. We primarily are to enact legislation, hold the executive accountable, and sometimes hold the judiciary also accountable. So our position is secondary to that of the judiciary in this matter. That was the context, and that is how the Speaker concluded that I was right in that instance, and therefore your motion should not be admitted.
Now, let's come to this present instance about the Appointments Committee. In this instance, you are saying that a referral that has been made by the Speaker to a committee of this House to exercise a function that constitutionally dealing with those matters, no one anywhere can stop Parliament from dealing with those matters until Parliament has completed the process of dealing with that matter.
You understand?
The Supreme Court has said that severally. And he just cited two cases in which members of this House have gone to the Supreme Court to try and get the Supreme Court to order this House to stop considering matters that the House was considering on the grounds that they felt it was unconstitutional for Honorable Minority Leader. Reference to the Constitution, to Erskine May, to all those things don't really make a difference. The matter is so simple and so basic. The Supreme Court of Ghana has said that when this Parliament is engaged in its primary responsibility, it will always allow this Parliament to go through that process to the end. And then, if the outcome is wrong or goes against a specific provision of the Constitution, then they, at that point, can make that determination. But once they are seized with jurisdiction and they are dealing with the matter, they will not interfere. I haven't seen a ruling changing this position of the Supreme Court. So, as for ECOWAS, yes, even ECOWAS court will always tell you that you should have fully exhausted local remedies before you come to the ECOWAS court. So if you are already in the courts of Ghana trying to vindicate your rights, you haven't finished in Ghana, then you jump to Abuja you jump to Abuja when you have not yet exhausted local remedies. I'll be surprised if ECOWAS court delves into your matter. I'm saying this because I have been a member of ECOWAS Parliament for close to a decade, and I know how that court functions. So I can assure you, without making any pronouncements now, that the principle at the ECOWAS court is that you must have exhausted local remedies before you go to ECOWAS court. Mr. Speaker, I plead with my colleagues. I know that the circumstances surrounding the removal of the former Chief Justice is a matter that especially my brother, the minority leader, has fought. He has embarked on street marches. In the process, some policemen even allege that he became physical against them. I can understand. I can understand that this is a matter that he is personally very passionate about.
Majority Leader, conclude. But
the Constitution is very clear on these matters. The nomination of the Chief Justice is properly before this House. It has been referred to the committee, and the committee will sit on Monday. I urge him to appear before the committee as a member. You can ask all your questions. The Chief Justice nominee is ready and available and willing to answer all questions put to him, and very, very capable. If at the end of the day, there is any decision by any court in this country, I'm sure the court will find a way of crafting a mechanism for enforcing their decision. The court will find a mechanism for crafting the enforcement of their decision. Mr. Speaker, the court, after we have completed our work in this House, have been able to strike down the conclusion of the work of this House. In that ruling led by Justice Yoni Kulondi, they annulled what we did in this House. So please, allow the system to work. Allow the system to work. So, honorable colleagues, I have presented to you the business statement for next week. The minority leader is a member of the business committee. The minority chief whip is also a member of the business committee. And so this business that we have presented to you is business that we agreed together as the business of the House for next week. And we urge you to approve it so that we can move on. As for the referral to the committee, that was done some time ago. It was not really part of the records of the business statement of this sitting. It wasn't. It is an old referral. What we did is to attach records of the old referrals to remind members that those referrals are still pending before them. But it is not a matter for decision today. The work of these committees are not matters for decision today. It is just to remind members that these assignments are pending before them. So the question of the appointments committee and what they are to do on Monday is not for decision today. It is a matter already referred by the Speaker to them. So if you are going to challenge the decision of the Speaker on that matter, you know the procedure to use. You know the procedure for challenging a decision that has been taken. So the Speaker has already taken a decision referring the nomination to the Appointments Committee. All we are doing is to remind all committees that businesses are pending before them, that they should endeavor to accomplish those businesses and bring their reports to us for decision. So you cannot get up and, like somebody did in secondary school exams, where the question was, what is a tree? Then he says, oh, a tree has branches. Sometimes birds perch on the trees, and one may ask, what is a bird? And then went on a tangent of explaining and describing a bird, because that is what he had prepared for in the exams. I am saying this because I know as a fact that he had filed a motion seeking to challenge the authority of this House to have the nominee considered by the Appointments Committee. He filed a motion. He raised it at conclave, and I reminded him that you cannot stop this Parliament from conducting its lawful business. I reminded him, and he told me, listen carefully, please listen carefully. He told me that he had prepared to argue that motion, and that even if I wanted, he would give me copies of his arguments that he would prefer. That is why I'm saying that he had prepared on an examination about a bird. He had prepared to argue a motion. He had prepared to please listen. He had prepared to argue a motion. He had prepared to argue a motion on the constitutionality of this House, considering the nomination of the Chief Justice. So even though that motion is not properly before this House, and what is before this House is the business statement for the ensuing week, he decided to argue his motion.
Honorable Majority Leader, kindly conclude.
So, Mr. Speaker, I think that the issues that he has raised are not properly before us. There's no issue about the sitting of the Appointments Committee. That is a matter decided already by this House. What is before you is the business statement, so that we can schedule activities for next week. Mr. Speaker, I thank you.
Honorable members, with all due respect, the minority leader in raising the issue indicated that he's not calling on the Speaker to make a ruling. So if there is an issue raised which the Speaker is not called upon to make a ruling, do we open it up for debate? Honourable members, with all due respect, he came out clearly to state that he's raising the issue but not calling on me to make a ruling. So we cannot therefore open this for a debate, with all due respect. So, minority leader, I will give you the floor. If you have something to say, then we make progress. But I don't intend to open this up for debate, because I am not being called upon to make a ruling. Our members, procedurally, if minority leader raise an issue and is not calling for a ruling, why do we debate this matter? So please, Minority Leader, I plead with you to be brief.
Mr. Speaker, with respect, first, perhaps my two colleagues who were up on their feet, what they sought to do was to seek your leave to contribute to the business statement. Mr. Speaker, the subject matter of this whole discourse is a business statement.
Yes.
So, respectfully, I believe that, yes, I would come in to respond to the issues that I disagree with. Mr. Speaker, you made some fundamental point, but the members...
Honorable Minority Leader,
yes, Mr. Speaker, yes.
With all due respect
yes.
to you,
yes.
If you intend to respond to what he is saying, before I could open the floor to take comment on the business statement, it will be fair and just that we conclude the issue that you have raised, then I can give them the floor to comment on the business statement.
Mr. Speaker, if that...
Not...
Mr. Speaker, let me finish.
Yes, Majority Leader.
Do you give me the right and then you
let me hear Majority Leader.
Before you come back?
Yes, don't worry.
Mr. Speaker, we all know the practices of this House. When the business statement is read, we start with comments from backbenchers.
That is so, I agree.
To the seniors. And then we end with the leaders. So, no one, unless there's something earth-shattering, no one after the Minority Leader has commented
in
on
fact,
business
without
statement.
cutting you short, I have the privilege of discussing this with some leaders from the minority side, that it is not always fair and just that we wait and give opportunity for our leaders after the leaders speaking. Then the back will want to have the opportunity to again speak. It is not a good practice. It doesn't sound well. So the leaders, I plead with you, anytime you want to speak, look at your back. Because once you have the floor, I think I even raised this on the floor of this house, that it is always good to look at your back. Because a leader must speak last. A chief must speak last. Yes, Honorable Habib.
Thank you, Mr. Speaker. Mr. Speaker, I'm guided by the fact that our leaders have spoken on this matter. And it is the business statement that the House needs to take a decision to either adopt, either the Majority Leader will make amends to it. That is what is stated in our standing orders in Order 71. Mr. Speaker, I want to draw your attention to something. As much as we are gearing towards taking, the decision on the business statement, I want to refer you to the Constitution in Article 104. And Article 104 of the 1992 Constitution states, and I read, Mr. Speaker, 1, that except as otherwise provided in this Constitution, matters in Parliament shall be determined by the votes of all members of Parliament present and voting, with at least half of the members of Parliament present. Mr. Speaker, for us to adopt this business statement, we are going to take a decision. And to take that decision means we need 138 members of Parliament present to do that. And we don't have. At the moment, we are 108 in this chamber. So for that matter, Mr. Speaker, we cannot adopt the business statement. Mr. Speaker, we cannot adopt the business statement at the moment. We cannot take that decision. We don't have 138 members. Mr. Speaker, to determine We don't have 138 members present at the moment to take a decision or determine for the approval of the business statement. And for that matter, Mr. Speaker, I invite you to apply the provisions in the Constitution in Article 104 that we don't have 138 members to adopt the business statement. And Mr. Speaker, the majority side, there are only 77.
Honorable Habib.
The majority side, there are 177.
Honorable Habib.
We cannot take that decision
Honorable
in
Habib.
the approval of the business statement.
Honorable Habib.
Because we don't.
I think your application is premature. We haven't got to a stage of taking decision. Minority leader has raised an issue. Minority leader has raised an issue. And it is the issue raised by minority leader that we are considering. Yes, majority leader. Yes, majority leader.
Mr. Speaker. Mr. Speaker, when the Honorable Habib was on his feet, he made reference to Order 71 and indicated that a decision is to be taken. And that is the basis on which he is raising the question of decision quorum. I rose up because he specifically mentioned Order 71. And before he went to the constitutional provision, he mentioned Order 71, then now raised the constitutional issues. So I think that we should read Order 71. Order 71 says, business statement. 1. Every Friday, the chairperson of the business committee shall present to the House a statement on the business arranged for the following week. Present to the House a statement on the business arranged for the following week. Where the first sitting of a meeting precedes a Friday, the statement on the business arranged for the remainder of the week, where possible, shall be presented on the day of the commencement of the meeting. And finally, 3 says, the chairperson of the business committee may present supplementary statements as determined by the committee. Mr. Speaker, a statement, not a report to be adopted by this House. A statement. I want you to read your standing orders properly and understand it properly. The order says the chairperson should give you a statement. The same way. Give me your. No. The same way that statements are made in our standing orders. Which statement has ever been made in this House that has had to be adopted by this House? Which statement? It shows that we have been doing the wrong thing. We have been doing the wrong thing. Mr. Speaker, I'm very serious. We have been doing the wrong thing. Because I am reading Order 71, and it says, every Friday, the chairperson of the business committee shall present to the House a statement on the business arranged for the following week. A statement. There's nothing there that says that you should adopt it or a decision. What you do is that if I present the statement and then
in your commentary on the statement, there is additional business that should be conducted by the House, then I make supplementary statements. And those supplementary statements then also provide notice of the other businesses that may be done in addition. A business statement is just a notice to you of what the agenda of the House is going to be. Mr. Speaker, so I don't think that there's no basis for raising an issue of constitutionality. There is no basis because, you see, there is a business committee. When the business committee meets, they are regulated by the provisions relating to committee work, which means that they have to adopt the outcome of their work. But when I come here as chairperson of that committee, I am not presenting a report that should be adopted by this House. I am making a statement outlining the agenda of this House for the subsequent week. That is the position. And Mr. Speaker, I invite you to look at Order 71-1 and what it actually means. I know all the time when the statement is made, members get up and then they raise issues that they think should be included, and then the leader would say, oh yeah, okay, we'll add that, and etc. That is in the nature of the supplementary statement. In the end, the speaker will usually say, oh, the statement is hereby adopted or put it to us, and that kind of thing. I'm saying that, strictly speaking, a statement is not a matter that should be adopted and accepted. It is a statement.
Honorable member, conclude. Yes, Honorable Habib.
Mr. Speaker, when I raised my issue, the majority leader, I need your attention, who says that the order that I stated was wrong. Mr. Speaker, when it comes to the standing orders, and on the front bench, this is my 5th year on the front bench, and I know my rules well. Read Order 101, Mr. Speaker, and I read A. Order 101A, Mr. Speaker said, a motion notice shall be given of a motion intended to be moved, except a motion number 1A, for the adoption of the report of the business committee. Is it a form of a motion? Yes, it's a motion that needs to be adopted. It's a motion that needs to be adopted. It is a motion that needs to be adopted. Mr. Speaker.
Honorable members, order.
Mr. Speaker.
Honorable Habib.
Mr. Speaker.
Honorable Deputy Whip.
Mr. Speaker, I read again.
Honorable Deputy Minority Whip. With all due respect, in adopting the business statement, do we put a question?
Mr. Speaker, I am drawing his attention that, Mr. Speaker, in Standing Order 101, Standing Order 101 reads that notice shall be given of a motion intended to be moved, except a motion A, for the adoption of the report of the business committee. Mr. Sir, how do you adopt a report in the parliamentary procedure?
Well, you indicated.
It's a report to the House.
Honorable Habib,
to be adopted.
Honorable Habib, you have indicated you've been a member of parliament at the front bench for 5 years. So, with the 5 years experience, do we adopt a business statement by putting a question?
Yes.
Yes, minority leader, you want to help us whether a business statement is adopted by putting a question? Yes, minority leader, let me hear you.
Mr. Speaker, with respect, Mr. Speaker.
Minority Leader.
Mr. Speaker.
Before you come in, permit me to acknowledge the presence of some students in our midst.
Very well.
We have a student from Regional Maritime University, led by Ochre Nana Kwesi Ba, head of the Students Representative Council. They are from Koa constituency, they numbered 40. We also have Kingdom Heirs Montessori, led by Joseph Ama. He is a facilitator. They are from Botiano, English, Amanfro. They numbered 82. Honorable members, on your behalf, I welcome all of them to Parliament of the Republic of Ghana. May you have a fruitful visit to Parliament. Thank you very much for coming. Yes, Minority Leader.
Mr. Speaker, I am on my feet on two issues. First, Mr. Speaker, our side have a concern. And it's a concern that is very collective. We have noticed that in many instances, when we are contributing, you interject with a lot of questions. However, the majority leader and his colleagues on the front bench, as well as the majority members, are allowed to flow. Mr. Speaker, we would plead with you that as much as possible, much as you give them the unfettered opportunity to make their submissions, please allow us also, because many times you interject with rhetorical questions and sometimes we read sarcasm in it. Unfortunately, sometimes we do, because if a member makes a submission, Mr. Speaker, the member, when Mr. Speaker, for the first time, I will take issue with the majority leader. Sometimes when we are all arguing and he disagrees, he has a way he uses a language so offensive that I have decided to always.
No, I thought you were addressing me.
I am not worried. I am never.
Minority Leader, I thought you were talking about.
Mr. Speaker, Mr. Speaker, I need to finish respectfully. He uses certain language. The matter you referred to, he came to say his argument at the dispatch box was with the effect that the business statement is a statement and not a report. He went further to say that for that matter, it doesn't need any numbers constitutionally provided to adopt it. And that's whatever we've been doing is wrong. The respected member for Tolon got up to remind him of Order 101A, which says that there are motions that require notice. And the business statement is one of the motions that no notice is required. And it has to be adopted. Let us pay attention to the language of our own regulation. It talks about adoption. How do we adopt reports in this house? How do we adopt reports in this house? Any report that is adopted must meet the threshold constitutionally provided. So he was on a firm grounds when he said that to adopt the business statement, we need a minimum of 138. He went further to say that at the time he was arguing, the majority had only 77 of their 189. That is a statement is made on record. And even now, as we count, you are now 82. We are still counting you. Yes. Yes. So after your super majority, exists merely enormous. Today, we are using soft and substance to challenge you. We are facing you with substance. We are not facing you with numbers. We know when it comes to numbers, you have it. That is why we have enriched our argument by doing research. That is why the member for Tolon is able to remind the majority leader that indeed He didn't make the application lamely. He didn't bring a lame application. Mr. Speaker, let us even pay attention to paragraph 1 of the business statement. Quote, Mr. Speaker, the committee met yesterday, Thursday, 6 November 2025, and arranged the business of the House for the 4th week ending 14 November 2025. Mr. Speaker, the committee accordingly submits its report as follows. Mr. Speaker, though the language statement is used, but the content of that document is a report. He is the chairman of the committee. Let's look at Order 216. The business committee comprises of the leader of government business as chairperson, the leader of the party or parties in parliament who do not form the government as a ranking, chief whip, and no more than 11 other members. Mr. Speaker, it goes on to talk about its proposed sitting and recommendations. Whatever the business committee does, it presents to the House in the form of a report. And 101A provides, and I quote again for the avoidance of doubt, at the risk of being repetitive, it says that notice shall be given of a motion intended to move except a motion for the adoption of the report of the business committee. Let's read them together. This provision and the first paragraph of your own report, the conclusion, and let's be very conjunctive. You cannot read them in isolation.
So, Minority Leader,
Mr. Speaker,
reading all the provisions in totality.
Yes, sir.
My question is not being sarcastic.
Mr.
It
Speaker,
can lead us to resolve the matter ourselves, and that is the best approach.
Mr. Speaker,
That is why my question is simple. How do we adopt a business committee's report or
Mr.
a
Speaker, by
business
taking a vote.
statement?
Mr. Speaker, the procedure for adopting a report in this chamber has always been by taking a vote. A vote, if it is challenged.
Leader,
Yes.
you've been in this house for
Yes.
a very long time.
Yes.
Can you mention one instance where we adopted a business
Mr.
committee's
Speaker,
report
with
by
respect.
a vote?
Mr. Speaker, with respect. Mr. Speaker, with respect. How do we adopt reports in this house? How do we? He, the majority leader, said, if in the past we didn't use a certain procedure, then it is wrong. That was he said. He said we have adopted the wrong procedure. That's what he said.
I do not think we should set a very bad precedent
Mr. Speaker,
by
we're not setting a bad
adopting
precedent.
a business
They
committee
need 138. They should bring their members.
statement
They say they
by
have
way
majority.
of a vote.
Bring your 138 and approve your.
Would have
the
been
business report.
serving a very bad precedent for this house. It has never happened before. I came here in 2013 in ruling government.
Speaker.
All members, minority leader first. Minority leader. All members, minority leader first. Minority leader first. Minority leader first.
Mr. Speaker.
Honourable members, I'm watching and the cameras are also watching. Yes, minority leader.
Mr. Speaker, the majority leader cannot get away with what he just said. Mr. Speaker, the rules of this House defines what the business statement is. It defines the business statement as a report and a motion. That is what the rule says. It is not me. It is not me who says that. It is the rules enacted by us. Mr. Speaker, the hierarchy of laws is an order paper. Is an order paper a rule? Mr. Speaker, when there is any conflict, the rule takes precedence. The law would always take precedence over any other thing. Where the law has provided in explicit terms that, Mr. Speaker, the business statement should come by way of a motion which does not require notice and it has to be adopted. The majority leader is urging upon this House to take it as a mere statement. Mr. Speaker, all that they are doing is to play games, filibuster, to increase their 82 to a comfortable number. We will not allow you. You are 82. Mr. Speaker, you must determine the constitutional issue. We don't have 138. You cannot use this to invite your members in. You are now 74. We will not allow you to use delay tactics to invite your members to come in. Mr. Speaker, we are not up to 138. If Mr. Speaker wants to make a ruling on this matter, Mr. Speaker should make the ruling and posterity will judge this House.
Yes, on this note, I'm being called upon to make a ruling. Let me hear Honorable Ahmed.
If you don't want to go by the rules and the Constitution,
yes, I will make my rulings.
Mr. Speaker,
I will make my rulings.
Mr. Speaker, let me conclude. Yes. Let me conclude with respect.
Okay, I thought you concluded and calling on me to make a ruling.
The majority leader cannot choose his convenience. When it pleases him, he says Constitution. When it pleases him, he says now his authority is order paper. He doesn't depend on Constitution and the rules book. We challenge him with order 101A. He has not commented on it. He doesn't want to respond to it. All he says is order paper. Mr. Speaker, a constitutional issue has been raised.
Honorable,
you have to rule on it.
Honorable,
we are not 138.
Honorable minority leader, are you done? I will proceed to give the floor to Honorable Ahmed Manda, Minister for Local Government. You have the floor. Minister for Local Government, you have the floor.
Thank you. Thank you. Hey, what I do?
Honorable Ahmed Manda, you have the floor.
Mr. Speaker, for the opportunity. Mr. Speaker, at least.
Won't you sit down? Hey, won't you sit down? Sit down. My friend, sit down.
It's okay.
Honorable John Dako, I recognize Honorable Banda, but not you.
Mr.
Honorable
Speaker,
Banda, you have the floor.
Thank you, Mr. Speaker. Mr. Speaker, with respect.
Honorable Asafoje, will you resume your seat?
Mr. Speaker, with respect, it is the responsibility of the leadership of the House, including we, the former leaders, Mr. Speaker, to support you to bring order in the House. Mr. Speaker, Parliament is a very serious House, governed by rules and procedure. Mr. Speaker, today, from Cabinet, most of we, the Cabinet ministers, after sitting in Cabinet, Honorable Aaron Edrisu, Honorable Mutaka, Mangul Self, and other colleagues moved to this House. Mr. Speaker, because of sitting in Parliament, we close at 2. Mr. Speaker, we've come to debate just business statement for 2 hours. Mr. Speaker, and the accusation is that Mr. Speaker, the accusation is that members on this side were not present. Mr. Speaker, we have 87 members on the minority. As I speak to you, you have only 25. Mr. Speaker, how can we come and sit here? 25 of you, when we have 110 members on the majority side. Mr. Speaker, for you to let us use 2 hours in debating business table, when you know the correct thing to do.
Yes, wait.
Mr. Speaker, for the records and for the standing orders, we were on that side.
Hey, Master, will you sit down?
No, Mr. Speaker, we were on that side. No, it's okay.
No, that gentleman over there.
It is not beyond us to know what to do. As former leaders and current leaders, Mr. Speaker, we know what to do. Mr. Speaker, do you remember what is happening today has ever happened in this chamber? How did we resolve it? They should know what to do. Mr. Speaker, you are the Speaker so long as this House is concerned. Business statement has been presented. It is within your jurisdiction and authority to give your command. Business statement is adopted subject to the recommendations. Then we move on. Mr. Speaker, currently, there is no motion before you. And when there is no motion before you, we cannot debate a motion that has not been moved. They should know what to do. Mr. Speaker, you know, when media reviews were reduced to statements, we stop voting on them. So if you don't know what to do, you've not done it, you can't hold that to ransom. Mr. Speaker, I'm a minister responsible for local government, chieftaincy, and religious affairs. From 2 o'clock, I'm sitting here, debating business sector. On that note, Mr. Speaker, so long as there's no motion before you, just move forward. Let's adopt the report. Subject to
Honorable Asafoje, if your leaders are asking you to sit down, please resume your seat. Why? At least if your whips are asking you to resume your seat, resume your seat. If you won't listen to me, listen to your whips. Honorable Roxanne Dapamako, let me hear you, but be brief.
Speaker, I'll be very brief. Speaker, within the terms of Order 122, the minority leader put out some figures regarding my membership on the floor. Speaker, please. Speaker, the minority membership
Honorable members, if things continue this way, I will not hesitate to invoke the rules by calling on you to either walk out. If you refuse, I would invite the marshal to walk you out. This is the House of Parliament. It must not be so disorderly. The disorderly conduct is becoming too much. We are honorable members. Yes, Honorable Habib. No, you haven't finished. Honorable Roxon is on the floor.
Off that mic. Speaker, thank you very much. Speaker, I'll be very brief. One, our standing orders defines terms of art, and this is contained in order 6 of our standing orders. Business statement is not defined. So the position by the minority leader that business statement is defined, it constitutes a motion, is inaccurate. Is not defined. He made the point that our standing orders defines a business statement. It's not been defined. So that is for the records. Two, Mr. Speaker, the minority leader has put out some figures regarding our membership on the floor. Speaker, our membership is over 142 on this floor. Speaker, they are 26. They are 26. We are 142. So, Mr. Speaker, it is a Friday political strategy to put it out in the media that my majority members were 82. So that the media will take it out, and for the whole weekend will be bastardized. We are on this floor. We are, oh please. So let the records reflect that we are 142. A count can be conducted. You are 25. You are 25. You are 25. So, Mr. Speaker, we have the numbers.
Honorable member, if you want to know the actual number in the House, as Speaker, I know how to do. I'll call on the clerk to do the counting.
Mr. Speaker, so I will not allow your number 82 to stand. So the media, we don't want anybody to go and report that the majority members we are 82. We are 142.
Honourable members, we have spent so much time on the business statement. To everything, there must be an end. So I'm pleading with you. Let's conclude issues on the business statement.
Okay.
And then we can make progress.
Thank you, Mr. Speaker. Mr. Speaker, I won't say much except that I have a pending application, but I want to draw your attention also to our standing order 24 A, B, C, and D. And Mr. Speaker, standing order 24 A says that the Speaker shall uphold the honor, dignity, sanctity of the House. B, promote consensus on matters under consideration in the House. And then C, be impartial, fair, and firm in matters. And Mr. Speaker, I want to invite you to abide by this. You have steered the affairs of the House so far very well. And I invite you that I have raised issue and the 1992 Constitution in Article 104 that matters to be determined in this House must be at least half of our members, which is 138. Mr. Speaker, I want to end and submit humbly that you know what to do as you indicated. The number I put previously when I made the application was 77. I still stand by it. If the clerk or you direct it otherwise, and there's a different number,
I will
respect your decision,
honorable members.
Thank you, Mr. Speaker.
Sometimes we know the procedure, but deliberately we want to put out a wrong impression. We have two types of a quorum. We have a quorum for commencement and a quorum for decision. Now, anytime the attention of the speaker is drawn to the absence of a quorum, speaker takes advice from the clerk. If we do not have the quorum, we ring the bell for 10 minutes and then the other consequential procedures follow. So when you make the application, in fairness, I told you your application is premature. I also indicated to you that by your submission in this house today, you have been in this house for 5 years, which we agreed to, and for all those 5 years you've been in leadership. Advise the speaker on a single instance where a business statement is adopted by a vote. Honourable members, when you know the truth, let's go by it. When the truth is known, let's just go by it. Let us not set a bad precedent. To quote the minority leader, whether it is 20 years or 30 years, the table may turn. I always take that aspect of his statement very seriously. So today, don't consider where you are sitting today and say business statement should be adopted by way of a vote. Honourable members, the truth is only one. There are seniors in this house who attest to the fact, a bare fact, that we don't adopt a business statement by way of a vote. So, honourable members, let's help issues. Where there is no problem, let us not create one. So the ruling is that business statements are not adopted by way of vote. On this note, the business statement as presented is hereby adopted. Members, before we proceed, let me indicate that on the issue raised by minority leader, he is calling on me not to make a ruling, and I intend not to make ruling. However, Mr. Speaker or the Speaker would be here to make comment on the issue. But I would want to state clearly, by way of advice to all of us, that when a procedure is set down for a right to be exercised, it is that procedure that will have to be followed in exercising the rights. Honourable members, when motions are filed, the motion is supposed to be admitted. It must pass the admissibility test. After the motion is admitted, it is programmed on the order paper. Until and unless that motion is programmed on the order paper, it cannot be debated. So, honourable members, we can't pass through the back door to do what is yet to be admitted. This is not a ruling, but is by way of advice to all of us, that a procedure is there to guide all of us. On that note, I'll defer any further comments to the Speaker. Majority Leader, let me announce the presence of students from American Cooperative School. They are led by Achampong Edward, headmaster, and they are from Efiduasi, Asokore. They numbered 117. All members, on your behalf, I welcome them. May you have a fruitful stay in Parliament of Republic of Ghana. Yes, Majority Leader. Yes, Majority Leader.
Yeah, Mr. Speaker, I crave your indulgence so that we can vary the order of business and then do some small public business. We have spent 3 hours already, 3 hours that should have been meant for private business. We have spent it debating the statement. So let's do some small private business. Public business. So, Mr. Speaker, permit me to invite you to vary the order of business so that the Minister for Education can lay item 10A. Item 10A.
Minority Leader.
Mr. Speaker, we don't have any difficulty. It can be laid.
See, the people are going again.
Mr. Speaker, issues concerning the Education Minister normally, and now there are people are now leaving the chamber after being whipped to come and vote on business statement. They are disappointed, so they are leaving the chamber. But the Education Minister can lay the paper.
All members, at commencement of public business, item numbered 9, presentation of papers. Or is rather item numbered 10A, presentation and first reading of bills.
An act to establish the Kwame Nkrumah University of Science and Technology, Kumasi, and to provide for related matters.
All members, the bill has been duly presented and it is referred to the Committee on Education. Yes, I am inclined to add the leadership of Constitutional Legal to help the Education Committee to consider this.
Mr. Speaker, again, I seek your indulgence so that we can vary the order of business and take some 2 clauses, just 2 clauses of the Ghana Scholarships Authority Bill. Just 2 clauses, Mr. Speaker. Mr. Speaker, just 2 clauses. Mr. Speaker, the agreement at conclave was that the Minister for Energy is unavoidably absent, and so we may not take his questions. That was the agreement at conclave. So, Speaker is a witness to that agreement. That was the agreement at conclave. So, in the absence of the Minister for Energy and Green Transition, I'm urging that we take the consideration stage of the Ghana Scholarships Authority Bill.
Yes.
Mr. Speaker, I think we can go ahead with that, considering the fact that the Majority Leader have changed his tone from the time he was presenting the business, so we can go ahead.
Thank you very much, honored members. Ghana Scholarships Authority Bill 2025 at consideration stage. He has instructed. Honorable members, going by the order paper, we have clause 3. So I'll call on the chairman of the committee to move the proposed amendment.
Thank you, Mr. Speaker. Mr. Speaker, amendment proposed. Paragraph I, delete and insert the following.
Yes.
Mr. Speaker, with respect, we're just told that we should comply with our rules. Where is the chair of the committee? Mr. Speaker, we need to know where the chair of the committee is.
Yes, Majority Leader. Majority Leader, they are asking of the absence of yes.
Oh no, but you can respond. Mr. Speaker, we note that the chairman of the Committee on Education is on official duties outside of the jurisdiction, and therefore, by our rules, a member of the committee may be permitted to lead the discussions on behalf of the committee. Mr. Speaker, we plead that you permit a member, the Honorable Edem Agbana, member for Ketu North, is a member of the committee. He is able and capable of leading the, and we did that yesterday, Mr. Speaker.
Yes, honourable members, as indicated, the Speaker is here to take the chair.
Okay, thank you, Mr. Speaker. I think we won't have any difficulty with Honourable
members. I also indicated that he has his comment on the issue raised by the minority leader. So, honourable members will have to defer the consideration of the Ghana Scholarships Authority Bill 2025.
You give me this one. Honorable members, I patiently observed and listened to you, spent considerable time debating a report of the Business Committee. I had so many things to do, but I was compelled to leave that and to come to clarify some issues, particularly what led to the long discussion was I thought it was not necessary at all. We will not suspend the consideration of the bill. After my submissions, we'll go on with the consideration of the bill. But let me see Honorable members, yesterday, I returned a proposed motion paper submitted by the minority leader, Honorable Alexander Afenyo-Markin, to the clerk in accordance with Order 1023, which according to the order is to be submitted to me as stated in Order 1024 as being inadmissible. As required by Order 1024 of the Standing Orders, I provided reasons on the face of the proposed motion paper for my refusal to admit the motion. I've this afternoon been compelled by what has gone on in the course of your attempt to adopt the report of the Business Committee, and I'm to provide my reasons to plenary as part of my efforts to ensure full disclosure. This, as you all know, is an administrative function. It's not something that should be done on the floor of the House. But the way the deliberations has gone on, it has left not only members, but our constituents a bit unclear about how we conduct things in the House. So this is an attempt to clarify the issue and to bring finality to the matter raised by the minority leader. Honorable members, the Clerk to Parliament received the proposed motion on the 28th of October, 2025. As I said, it's a proposed motion. And so it's couched in the form of a motion by the minority leader, as required by the Standing Orders. It was forwarded to my office the same day. That's the 28th of October, 2025. My office at the Secretariat received it, and it was later transmitted to me. It was now my duty to administratively consider the admissibility or otherwise of the motion. In considering the admissibility of the motion, I was guided by the provisions of the 1992 Constitution, the Standing Orders of the House, and precedents of parliamentary practice. Honorable members, a motion as defined in Order 6 of the Standing Orders of this House is a proposal made by a member of Parliament or a committee to do something or order something to be done or express an opinion concerning some matter. Orders 102 and 103 vest discretionary powers in the Speaker to determine whether a motion is admissible or not. In exercising this power, the Speaker must be guided by provisions as stated in Order 103 of the Standing Orders to either direct that the motion be printed or the motion is to be returned as inadmissible. Honorable members, I have considered deeply the proposed motion. I considered the text, and I concluded that there was no basis for me to exercise the discretion to admit the motion. I have a copy of the proposed motion here. The motion, in summary, suggests that Parliament, as an arm of state, should stay its hand until another cognate arm of state takes action on a matter pending before it, even when there is no definite time for that arm of state to take the action. I find this suggestion constitutionally and procedurally unsustainable. Article 144, Clause 1 of the 1992 Constitution gives Parliament a clear and continuing duty to consider a president nomination for Chief Justice. That duty is not conditional on events elsewhere. There is no constitutional or standing order basis for Parliament to hold the process simply because there are pending cases in court. Should I accept that argument, it will mean that any litigant could hold Parliament hostage, that is, file a case and freeze the work of Parliament and its committees. That would undermine the concept of separation of powers and paralyze the constitutional machinery for filling, for example, in this particular case, key offices of state. Honorable members, I'm very mindful of Article 2 of the 1992 Constitution, especially Clause 2 of Article 2, which vests the Supreme Court powers to make orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to the declarations it has made. This article clearly states that should there be any unconstitutionality regarding the removal of her ladyship, Justice Tokunu, the court is vested with the power to so declare and make all necessary orders needed to restore the status quo. To that end, I'm of the view that courts can continue to hear whatever matters are pending before them, but until there is an injunctive order, Parliament's authority remains intact. Judicial independence should not mean legislative paralysis. In any case, I have consistently questioned whether the Supreme Court could use its injunctive reliefs to stultify the work of another arm of state. Is that the purpose of that relief? Honorable members, procedurally, I'm also mindful of Order 103, Rule F, which suggests that a motion shall not be a subject matter of an action in which a judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interests of the parties in the action. I have considered the provisions on admissibility of motion, and I submit that the proposed motion is out of order. As I have already indicated, I am convinced that the Supreme Court is vested with adequate powers to reverse any action should they deem them unconstitutional. This matter I have discussed with the minority leader who was bent on the motion being admitted. It's not that I'm just saying them now. But he gave me notice that he will definitely air his views on the floor. And I think that is why, as the majority leader said, even though you were discussing football, he brought in Ampe. In summary, honorable members, the major points of this ruling is that the motion is inadmissible, and same has been returned to the sponsor, the minority leader, Honorable Alexander Afenyo-Markin, as stated clearly by our standing orders. I thank you all for your attention. Honorable members, minority leader, you want to have another bite?
Respectfully, Mr. Speaker, I would want, with your leave, to respond to a matter because of Hansard. Mr. Speaker, we have reputational issues here. There are matters that perhaps you may not be in the know. And for the sake of tomorrow, I believe that I must not be denied the opportunity to make this point known for Hansard, because points have been made by you, added to your ruling, and it has gone into Hansard. Mr. Speaker, with respect, as you rightly stated, we filed this motion on the set date. We were very vigilant enough. We followed it to the clerk's office and ensured that same had been transmitted. Mr. Speaker, days passed. The clerk communicated to me that my motion cannot be traced. Mr. Speaker, yesterday I followed up again because I know that he who comes to equity must do equity and must be vigilant. Equity has never favored the indolent. So I didn't want to sleep on my rights. I followed up again at conclave and I asked the clerk to Parliament, has my motion had any decision so that the caucus can know what step to take in accordance with our rules? He then told me, Mr. Speaker, that you've asked him to now procure a copy of the motion from me because what was submitted could not be found. Mr. Speaker, this is truth and it's indivisible. I then procured my copy because I kept a copy in my file. Then he later said he's sent for his copy because he also kept a copy. I didn't allow him alone to come. I worked with him all the way to your office to make sure that the copy had been duly submitted, which you duly received. Mr. Speaker, I did not receive any communication until 3, the time is here. And sometimes people would want to do things, and if you are not careful, you lose your reputation. Mr. Speaker, with respect, it is here. Mr. Speaker, the time is 16:32. 1632. When that is 432, after we had raised the matter, it was now sent, your minutes was sent to me via WhatsApp. Mr. Speaker, I am a student of this house. I won't do anything to embarrass myself. If I'm not sure, I won't do it. And I will not seek to embarrass you or embarrass my caucus. I don't want Hansa to record me as having acted in bad faith. Mr. Speaker, we filed this notice long ago. There is vetting on Monday. Vetting on Monday. We don't sit on Monday. What other time would we have as a caucus to air our views? Even now, your response has not been officially been communicated to us. We don't have it. Mr. Speaker, I will speak the truth on this matter, and I wouldn't want any impression to be created that I did something wrong. We don't have it. It is now that you have, Mr. Speaker, with respect, read out in public your reasoning. We will pick it. What time again do we have to file another process to air our views? But Mr. Speaker, this is Parliament. We will respect it. Mr. Speaker, we even attach our written submission. That was how transparent we were. We didn't just send a lame application. We attach a written submission with all the authorities, including the latest authority in this house, where the majority leader argued that Nana Boachi's process at the Supreme Court, which process was seeking some declaratory reliefs, should stop this house. And Mr. Speaker, the first Deputy Speaker, ruled in his favor, upholding his application. You may recall, Mr. Speaker, that I came to you with an appeal, and you admitted my appeal, and a motion for review was filed. Mr. Speaker, the motion for review is still here. This is the motion for review. It is in today's motion paper, order paper, motion 15. The pursuant to order 127 of the standing orders.
Just a minute.
Oh, Mr. Speaker, if you want to come in.
Normally,
he can have his right to speak after me. Mr. Speaker, at this point of order, I don't have a problem. Mr. Speaker, I don't have a problem. I don't have a problem. He can speak.
Mr. Speaker.
Honorable Majority Leader.
Yeah,
just
Mr.
a
Speaker.
minute.
Mr. Speaker.
Just a minute. Minority Leader, I've given you all the space to speak because you raise an issue of it. There are some matters I raised which may affect your integrity. That's why I gave you the space. Now, you stated something which ignited the immediate reaction of the Majority Leader and stood on his feet. I signaled him that he should allow you to land. But it seems the issue he wants to raise is so critical, he was drawing my attention. No, let me do it. So I just wanted you to hold your breath for him to do so and let me rule. Please. Majority Leader.
Yeah, Mr. Speaker, he filed a motion. You took a decision on the motion. You transmitted the decision to him. Whether it is hard copy or electronically, he has admitted that he has received your communication. You followed through and came to this house and communicated the decision. When he said you should give him permission to say some things because it had to do with integrity and credibility, we indulged him. Even my chief whip urged me to object. I said no. He's raising administrative issues. So let us have that clarification. But
He's now going beyond that and litigating your decision. He is litigating your decision. He is arguing points of law in relation to your decision. He knows what our rules say. If you want to challenge the decision of the Speaker, you know how to do so. So please, you know the right thing. You may not be happy with the outcome, but this is not the procedure. You've raised the administrative issues. I think you've exhausted those ones. You have no right immediately to start arguing against the substance of the ruling of the Speaker. That will not be allowed.
Yes, Minority Leader.
Speaker, with respect, the beauty of our engagement here is the opportunity, unfettered, as the rules will permit, to air our views. So I respect what the Majority Leader said. However, I submit that he misunderstood the point I was making. Mr. Speaker, clearly I was on the point where I was drawing attention to the fact that at all material times where dissatisfied, I had followed due process, including the very subject matter of your ruling. Mr. Speaker, he had objected on same ground that a matter was before court, and the first Deputy Speaker had ruled in his favor. When I was dissatisfied, I filed an appeal before you, which you admitted, and that appeal has been pending since 5th of March. It is listed in today's order paper as motion 15, and quote, that pursuant to order 127 of the standing orders, the Right Honorable Speaker reviews the ruling of the first Deputy Speaker on the 5th of March, sustaining the preliminary objection raised by the Majority Leader, Mr. Mahama Ayaraga, against moving the private member's motion listed as item 16 on page 6 of the order paper of Wednesday, the 5th of March. Mr. Speaker, perhaps if the space had permitted for us to determine this review application, maybe the approach...
Honorable Minority Leader, you are now going far beyond bounds. You know the tools of filibustering.
Mr. Speaker, no.
And the tool of playing to the gallery. I think this is what you are now employing. And I want to stop you at that. I don't want to go beyond that. But clearly, I allowed this to happen because you took responsibility for the motion and you personally came to me. But on the face of the motion, the sponsors of the motion are Honorable Anyumedu Entry, MP for Asante Achim Central, Honorable John Darko, MP for Swami, Honorable Gloria Owusu, MP for Trobo, Honorable Damata Salam Amma, appear the motion that in paper with no attachment of any submissions. Please, these are administrative matters, and I am not to bring them to the House. But because you brought the matter to the fore in plenary session, I'm compelled to do so. Let's end it here, because you can always trace and trail submissions of documents through the administrative processes. There is no document that is received by my office that is not noted in the records of the Secretariat and copies of the document kept in the Secretariat. We have all. So there's no way that a motion paper will pass through my Secretariat, come to me in a minute, and then it cannot be traced. It's not done, because we have copies there, and even the minutes that are put on the paper are also captured in the records of my Secretariat. So if members are not aware, you can easily trace these records. Nobody can tell you that they can't trace the records. They are available. And by my training, I keep records. I know one day when I'm not here, some people may raise some issues. And all of you holding responsibilities, you might be prepared to answer. Whether in 10 years or 20 years, allegation can be made against you. You need to defend yourself. You need to have records. Don't just leave them and go, and when you are called upon, you are found wanting because you are naked. So I have all this. Let's move on to the motion that was referred to earlier on for us to continue with the consideration of the bill. Please. Honourable members, we go to page 7, item 17 of the order paper. Ghana Scholarships Authority Bill 2025 at the consideration stage. Honourable members, on the order paper, I see that we have 17 Roman 1, which deals with clause 3. If that is where you've got into, then I'll call on the chairman of the committee to move the motion for amendment of that clause.
Thank you, Mr. Speaker. Mr. Speaker, clause 3, amendment proposed.
Oh, are you the chairman of the committee?
Mr. Speaker, my chairman is not available and permission has been sought for me. He asked.
Oh, permission has been sought for you, and it was granted by my, yes, First Deputy Speaker.
Yes, Right Honourable Speaker, all the clauses here were deferred clauses. So we've done everything, but clause 3, 4, and 5 were deferred clauses. So we are not starting from clause 3, moving to clause 4, 5, 6 onwards. We've done everything, but these are only deferred clauses.
Exactly that. So I asked him to move clause 3.
That is okay.
As proposed.
Yes.
But because he stood up and I recognize that he's not the chairman.
Honourable Speaker, whilst I was in the chair,
you granted him?
Yes. There was an indication that the chairman is outside the country attending to official duties at UNESCO in particular. So both parties agreed that in the absence of the chairman, a member of the committee could move the amendments. Hence, Honorable Adam Agbana is moving the amendments as a member of the committee.
It's just that it's procedural because I said chairman of the committee. And so he stood up. But I didn't get this explanation. And so, my good son, you may do so once you have the leave of the Speaker.
Thank you, Mr. Speaker. Mr. Speaker, Clause 3, amendment proposed. Paragraph I, delete and insert the following. I, award foreign scholarship for a program including skills upgrading that is not wholly available in the country. I so move.
Honorable members, motion is moved for the consideration of the House. Yes, honorable member.
Thank you very much, Right Honorable Speaker. Right Honorable Speaker, I want to make a counter proposal to this particular amendment. Mr. Speaker, if you look at the original...
Honorable member, you want to plead to put a counter proposal, or you want to amend further the proposal?
I want to amend further, Mr. Speaker. Thank you for the guidance. Right?
Thank you.
Speaker. Yes, Mr. Speaker, I'm making reference to the intendment of the Act, trying to ensure that scholarship that is granted are supposed to be for programs that are not wholly available in Ghana. And so in the instance where this application or this amendment is seeking to award foreign scholarships for a program including skills upgrading, that is not wholly. I believe that the word not wholly is very, very subjective and difficult to determine. Because what constitutes not wholly available in Ghana? So I think that the not wholly should be deleted or taken out of it so that we stick to skills, a new rendition to the effect that it should be a program including skills upgrading that is not available in Ghana. Thank you very much, Mr. Speaker.
Do I give to my deputy? I think that the minister should have the bite before you. Yes, Minister for Education.
Mr. Speaker, I'll urge the last speaker to be persuaded to abandon his amendment. Mr. Speaker, the Committee of Vice Chancellors drew my attention, led by the Vice Chancellor for the University of Ghana, that they have what they call split-side degrees, where part of the program is taken in the country and a part abroad. This is what informed this proposition. I thank you. You may be doing a course, you have to spend 1 or 2 years in Ghana and spend another 1 or 2 years abroad in order to be able to complete it. If we restrict it to only what is not available in Ghana, it may be difficult for that category of students. That's why the committee was persuaded to reword the rendition. I thank you, Mr. Speaker.
You're not persuaded? Yes.
No, Mr. Speaker. I think the rendition doesn't give that impression, because if you say not wholly available in Ghana, it means that the course is not available in Ghana. But when, please allow me to make my point. But if you say that, but from his explanation, it is speaking to cross-country programs. That is different from a program that is, if we say a program is not available, it means that that program, you can't find it in this country. That is what I understand by not available in Ghana. And that is why I believe that scholarship that is being awarded to students, we need to take a decision whether it should be granted only for courses not available in Ghana. And if we intend to make courses that are partially available in Ghana, or the rendition that is there, it lacks clarity and it will be difficult for anybody to understand and give this as a meaning to scholarship that is not available in Ghana. So I'm not convinced with that. Thank you, Mr. Speaker.
Yes, please. I'll come to you. Let me listen to you.
Most grateful, Mr. Speaker. Mr. Speaker, I want to join the Honorable Minister for Education in urging my brother to abandon the proposed amendment that he wants to do to this. Mr. Speaker, the original rendition was award foreign scholarships for only programs that are not available in the country. Speaker, over the years, we realize programs that are only available of it outside. That is the reason this new rendition now says programs including skills upgrading, that is not wholly available. It may be available, all right, but it does not end. And so I urge my good friend to abandon his further amendment to what already exists. I thank you, Mr. Speaker.
Yes, First Deputy Speaker.
Mr. Speaker, thank you for giving me the opportunity to persuade my honorable member. Right Honorable Speaker, the original rendition in I is award foreign scholarships for only programs that are not available in the country. And our attention has been drawn to the fact that currently there is a program called Split Side. And that program, part will be offered in the country and part will be offered outside the country. Therefore, if you limit the award of scholarship to only program not offered in the country, it means you'll be denied the category of people admitted for that split side program. So in view of that, it is necessary to amend for the rendition to cover those people who would study courses that are not wholly in the country. That was what informed this particular rendition. If you leave the old rendition, then it means the category of the people who will be involved in the split side program who will not have the opportunity to be given scholarship.
Yes, Honorable Member for Kwadaso.
Mr. Speaker, thanks for the opportunity once again. Mr. Speaker, I remember when we met at Pediase looking at this bill, this matter came up, and I remember I raised the point that if we go by the original rendition, we are going to deny others from enjoying the scholarship. I remember it was not agreed upon. I'm happy that it has now found favor before the committee. So I support the current rendition because I used to be the CEO for National Accreditation Board, now GTEC. And we know how the systems work at the tertiary level. There are some programs, Mr. Speaker, they might even be run in this country and elsewhere, but in terms of the infrastructure, in terms of facilities, they might be enhanced or at an advanced stage out there than here. So if you say that you're not going to allow them to benefit, then it's going to be discriminatory. So I also want to urge our colleague that this current rendition best supports the intention of the bill so that it doesn't exclude others who, per the program they are pursuing, from enjoying the scholarship. Thank you, Mr. Speaker.
Well, honorable members, between wholly available and fully pursued, which is preferable? That rendition has been given to me too. That is not fully pursued in the country. And then that is not wholly available in the country. Which one is preferable? Matter of policy. Minister.
Mr. Speaker, I was consulting with the first deputy, who is a modern draft person, to help see if I can get the words split side programs. Those are the words the Vice Chancellor of the University of Ghana, Professor Nanaba, shared with me. And she provided further elucidation to explain what that meant. Fully pursued, Mr. Speaker, will not do any harm, but maybe we could have said award foreign scholarships for a program, including split side programs and skills upgrading. That is not fully pursued. I'll go for that, but I'll bring in the word, the split side. And Mr. Speaker, just as you are guiding us, for instance, she studied medicine. Yes. And she studied a particular enterprise of medicine.
Yes.
Today, she probably may need artificial application of medicine in dealing with the same enterprise of medicine. That artificial intelligence leg may not be available. So if we can do it, I'll be guided with your words, not fully pursued, but I'll still import the words split side programs. And then we define split side program in the interpretation as a technical word. Thank you.
Yes, please.
Thank you, Mr. Speaker. Guided by what you said, I believe that programs are mostly run. So I would have suggested the award foreign scholarship for a program including skills upgrading that is not fully run. That is not fully run in the country. So that would, I believe, rather than.
So you prefer run, not pursued. Drafting is a very difficult subject, and language matters. I being a former Minister for Health, I'm aware even our country will also benefit from that. Sometimes some countries in the study of medicine don't have the level of clinicals that we do here. So they will study the biological sciences and the rest and bring their students to Ghana to come and continue with the clinicals. And so you have those things happening, and particularly with modernization and the introduction of new technology. For example, robotics, AI, and the rest. So you have those split things. The idea is good, it's well accepted by all, is the appropriate wording that we are now trying to build consensus on. And so I got this, and I want to put a question. Award foreign scholarships for a split program, including skills upgrading, that is not fully run in the country. Is it acceptable? Yes. Yes, I would just advise that the draft person will put it in the appropriate words, but definitely what she's trying to do is to make it two, not one sentence, but separate the programs from the skills so that you have award foreign scholarships for split programs, which will be different, not fully run in the country, and then another for skills upgrading, not fully run in the country. That's what she's trying to do. But I'll put the question on the main idea, which is accepted. And you know, the rule now is after we finish the consideration stage, the whole bill will be compiled and brought to us before we go to the third reading. So when it comes to us, we'll see how it's being captured. If there's a need for us to do a second consideration, then we'll do so. In the meantime, the question is that those in favor of the motion as amended, say aye. Aye. Those against, say no. The ayes have it. The motion is carried. Now, I proceed to put the question on clause 3. And the Honourable Member, actually your proposal is not on the order paper, and therefore I'm finding it difficult to, capture it as we just moved. And as I indicated earlier on, if there's a need for us to do a second consideration stage, when it's compiled and submitted to members, you may come back so that we can move. Yes, Minister.
Mr. Speaker, I believe my colleague should reread the K. Ensure effective decentralization of the operations of the authority to the district and regions of the country. I don't see any problem with it. Mr. Speaker, the Scholarship Secretariat is normally housed in Accra. So what this is suggesting is that they should seek to decentralize their operations. By Ghanaian constitution and law, when you are decentralizing, where do you decentralize to? Either a regional coordinating council or a district coordinating council. We don't want them to just be in Accra. So if you are an applicant from Boedu in Sefi, and you can go to your regional coordinating council to make a case that you are seeking a government scholarship, must you necessarily come to Accra? So, Mr. Speaker, this is futuristic to ensure effective decentralization of the operation. When it is established, then they can do that. Thank you.
Yes, please.
Mr. Speaker, in fact, the scholarship secretariat as it is now, the operations is actually decentralized. They have committees at the district assemblies that are interviewing applicants. It's already decentralized. And decentralization simply means their operations is not centralized at the national level. So you can have them at the regional level, the district level, and even zonal basis. So my brother should abandon his position so we can make progress in this matter. Because
Honorable members, I think these are matters you can discuss with him.
Yes.
As I indicated earlier on, he may not be persuaded to come back, so that we can go ahead. Honorable members, I put the question. The question is that clause 3 as amended be ordered to stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Honorable members, clause 3 as amended is ordered to stand part of the bill. Clause 4, that is Roman 2 of item 17.
Thank you, Mr. Speaker. Mr. Speaker, clause 4, amendments proposed. Sub-clause 1, paragraph B, add the following new sub-paragraph. Ministry responsible for gender. I so submit.
Honorable members, motion is moved. It's for the consideration of the House. Yes, please.
Thank you very much, Right Honorable Speaker. Right Honorable Speaker, under clause 4, we're looking at the governing body of the authority. And already under B, we have ministers for education, ministers for finance, labor, jobs, employment, youth empowerment and development, and we have foreign affairs. So over here, on one governing board, you have about 5 ministers already represented on the board. I just want to understand how and why we think the ministry responsible for gender should also be added to make it sense. I believe that we shouldn't be encouraging more ministries representatives on boards like this, rather than looking at more technical people onto the representation of the board. So I think the already existing ministers are adequate to cater for concerns on the issues of gender. So I'm proposing that this be abandoned. Thank you very much, Mr. Speaker.
Honorable members, you should also be cautious of the fact that the concept we are practicing is that the government is usually ultimately held responsible. And so if you talk about technical people handling these matters, whilst you, the member of parliament, is being blamed on the ground, when you have no hand in it, or the government is not the one having the controlling power, you see that will be stray bullets. And so if you have the ministers who are to assist the president, who is the one giving the constitutional mandate to house the executive authority to implement these policies, the ultimate responsibility should always with that executive. Then we can hold them to account, and that's the duty of Parliament. But definitely the inclusion of gender is to make sure that there will always be some gender consideration in this matter. not only in the board, but in the awards of the scholarship, so that our fairer side are not marginalized in these matters. So I think the gender thing is quite appropriate.
Mr. Speaker, admittedly to your guidance, but that will make the composition even to 12, because already, if you check what we had, that was an 11-member board. And so when you bring the Ministry of Gender, it will make it a 12.
That's a genuine concern. That's even, and for decision taking, unless you do something else, it could be a deadlock. Yes, please.
Mr. Speaker, I'm sure the committee has taken note of it. There will be one additional nomination to the governing board. Mr. Speaker, if you recall, after the second reading, there was an uproar by civil society groups in education who were making a good case that they be represented on the board in order to allow for transparency. So we may be proposing a member of the civil society group in education would nominate one of them to serve on the board. Thank you. So we may bring the number to 13, Mr. Speaker, but that's left to the committee.
Yes, actually, the proposals are there in the amendments. So please, members, may we go on? I put the question. Those in favor of the proposed amendment as captured on item 17, Roman 2, say aye. Those against say no. The ayes have it. The motion is carried. We move to Roman 3.
Thank you, the Right Honourable Speaker. Amendment proposed. Subclause 1, after paragraph D, insert the following new paragraph. One representative of the Student Loan Trust Fund, not below the rank of a director, nominated by the governing body of Student Loan Trust Fund. I so submit.
Honourable members, motion moved is for the consideration of the House. Let me listen to. Okay. Yes.
Speaker, I support the present amendment, except to propose a further amendment to say that instead of one representative, we should indicate specifically that it should be the CEO of the Student Loan Trust Fund, so that we are very clear. It should be the CEO of the Student Loan Trust Fund who should be nominated by the governing body of the Student Loan Trust Fund to serve.
Why? Why do you want to take that thing from the students? In deciding who should represent them, why do you want to take it away?
Mr. Speaker, because the Student Loan Trust Fund is also set up to offer financial assistance. But we believe that the administrative head, who is the CEO, will better serve the interest on the scholarship board.
I'm not too sure about that, because loans are different from scholarships.
Mr. Speaker, yes, I agree.
Yes.
I agree. But it is for a purpose. It is for a purpose. And two, Speaker, instead of saying one representative, it should be a representative. A representative. A representative of the Student Loan Trust Fund. So, and in subsequently, where we are using one, I believe that it should be a. I think that is the drafting style that we've
adopted. That's correct. You are right in that direction.
A representative.
Let's consider the first leg of his submissions. Yes, please. Honourable Habib.
Mr. Speaker, it's like he has abandoned his point, because one representative of the Student Loan Trust Fund, not below the rank of a director. Even if his proposal is anything to go by, I don't think the CEO is below the rank of a director. No, you said we should state that it should be the CEO. But if the rendition is to be not below the rank of a director, the CEO is not below the rank of a director. So what would be the reason And you know, the CEO will be a political appointee. So if they are looking for a director to be a representative of the scholarship secretary, I think the way it stands is okay.
Mr. Speaker, the ministers who are to be represented are also political appointees. The representative of the ministry. So, yes. So, Speaker, I will disengage. But I want to propose that where we use the phrase one representative, the drafters, they know that we ordinarily will use a representative.
Actually, the drafters say we don't use a, we use one, because the a causes all the representatives are a representative.
Yes.
But to make sure that they don't go beyond that, but stay
a specific
to one
number.
Yes, so we'll be using one representative.
Speaker, I'm guided.
Yes, please. Honorable members, I put the question. Those in favor of the proposed amendment to clause 4 as captured in Roman 3, item 17, say aye. Those against say no. The ayes have it. The amendment is carried. Go to page 8, Roman number 4, clause 4.
Thank you, Mr. Speaker. Mr. Speaker, amendment proposed. Subclause 1, after paragraph F, delete 3 and insert 2. I so submit.
Honorable members, motion is moved. Is now for the consideration of the House. There being no further consideration, I put the question. Those in favor of the proposed amendment, say aye. Those against, say no. The ayes have it. The motion is carried. The final amendment to clause 4.
Thank you, Mr. Speaker. Amendment proposed, subclause 1. Insert the following new paragraph. One representative of civil society nominated by the minister. I so move.
Motion moved is for the consideration of the House. Yes, Honorable. Minority Deputy Whip.
Mr. Speaker, I don't know if the acting chairman can throw more light, because if you say one representative of civil society, it's not too clear. Civil society in what? You know, if he can clarify that. Okay, Mr. Speaker, so maybe the first Deputy Speaker is guiding me here. One representative of civil society in education, nominated, and then the question is that why must the person be nominated by the minister? Can the said civil organization also nominated their own person? But why should it be done by the minister?
Yes, any explanation?
Yes, Mr. Speaker.
Yes.
Mr. Speaker, the first correction that he did is exactly what we had proposed. So one representative of civil society in education.
Yes.
Nominated by the minister. Indeed, we recognize that there are many civil society organizations, and if we leave that to just say nominated by themselves, putting themselves together becomes a problem. And so we think that the ministry coordinates the various civil society organizations in education. And so they will be in a better position to nominate somebody from one of the organizations.
Yes, please.
Thank you very much, Mr. Speaker. Mr. Speaker, there is the Ghana National Campaign on Education, a coalition on education, which is a civil society network, duly recognized. And it's GNEC, Ghana National Education Campaign Coalition. It's the umbrella body for all civil society organizations that are into education. Mr. Speaker, and I know this as a fact because I've worked with them in the past. Mr. Speaker, we may be looking at couching the rendition to reflect the network. So the proposed amendment, for me, one representative of the civil society network on education, nominated by the minister or nominated by the organization coalition, and then probably all of them are being appointed by the president, right? So nominated by the coalition will be better rather than the minister. Yeah. Okay. So Mr. Speaker, let me make my proposal a bit more clear. One representative of the civil society network on education, nominated by the coalition in collaboration with or in consultation with the minister. Yeah.
Yes, please. Yes, Majority Chief Whip.
Speaker, we also have Ghana National Education Campaign Coalition, GNEC. Oh, I see. But the fear is that these coalitions, they often break up. And as we speak, Parliament is running itself into some problems, especially where we've legislated in the years before, using, for instance, the Ghana Bar Association. We also have Ghana Law Society. Yes, we also have Ghana Law Society, of which I'm the president and member, founding president. So, Mr. Speaker, you have to ask my members. You will discover that this house, since 2017, we haven't enacted legislation specifically mentioning Ghana Bar. We haven't. So we are trying to avoid specifically mentioning societies in our legislation. As we speak, I am in court.
Honorable members, you don't need to split hairs over this.
Yes. So,
we are in a free society.
Yes.
And therefore, we want to open it up to the best.
We should do a coalition of
it's not
civil society.
Every person in the civil society that is a member of the coalition. And we have some good materials who are not members of that coalition. And so experience has shown that we don't put fetters in the way of our enjoyment of the freedoms that are guaranteed under the 1992 Constitution. So I agree that we should talk about one representative of civil society in education nominated by the minister. Those in favor of that proposed amendment say aye. Those against say no. The ayes have it. The motion is carried. And now put the question on the whole of clause 4. And the question is that, yes, sir.
Thank you very much, Right Honorable Speaker. When I check the number in terms of the constitution of the board, best practices have shown that normally you have to make sure that the numbers are odd.
Yes.
I am now seeing if my mathematics will be right. I see that the numbers may be an even number. And so if it will be appropriate that we rather take one out or we add one so that you will be able to have an odd number which is in consonance with best practice as far as governing boards are concerned. So,
yeah, let me put a question on, well, yes, it's dealing with clause 4. You are right. Because this was earlier on raised by, I think, the Prof. He's not there again. But the indication was that we're going to add some more numbers. But what we've added again has taken it to even number. So the point that he's raised is right. We have to address that. Yes, please. So we move on, and then later on, maybe second consideration. Yes. So I put the question on the clause 4. When we are doing second consideration, then we consider that issue. Sorry. It's 13. The number is 13. Yes?
Okay. The clause 4 actually cures what he was raising. So the introduction of the civil society adds the number to 13.
Honourable members, let's move on, and you cross-check later. If they need to do second consideration, we'll do that. Honourable members, I put the question. The question is that clause 4, as variously amended, stands part of the bill. Those in favour say aye. Those against say no. Honourable members, the ayes have it. Yes.
Speaker, the proposal is that we should add NUTS to the board. National Union of Ghana Students.
I beg you, don't react.
So we'll come back.
Let's
second
respond.
consideration to cure that.
Go and consider it.
Thank you.
And make sure that you are doing the right thing. Yes. It's very easy when we are doing the third reading. If it's settled, we just put it in. There's no problem. So, honourable members, clause 4 as variously amended is ordered to stand part of the bill. Clause 5.
Mr. Speaker, clause 5. Amendment proposed. Paragraph E. Delete and insert the following. E. Monitor the use of funds of the authority. I so move.
Motion moved for the consideration of the House. Yes, please.
Mr. Speaker, I don't know why the chairman is taking out accountability from it. So we propose that monitor and evaluate accountability of funds of the authority. So, Mr. Speaker, accountability, monitor the use of the funds of the authority. So I rather propose that we do monitor and accountability of the funds of the authority.
You monitor accountability.
Mr. Speaker, I said monitor. Because, Mr. Speaker, the original rendition was monitor and evaluate accountability of the funds of the authority. But at the moment, the new proposal would be monitor the use of funds of the authority. But, Mr. Speaker, at a point there must be accountability. So I was proposing okay, Mr. Speaker, I have abandoned it because it's on clause 5 VII. Accountability is mentioned there.
Honourable members, there will be no further deliberations on this matter. I put the question. Those in favour of the proposed amendment say aye. Those against say no. The ayes have it. The motion is carried. We go to the next proposal on the amendment of clause 5.
Thank you, Mr. Speaker. Mr. Speaker, amendment proposed. Paragraph F. Delete and insert the following. F. Ensure accountability in the management of the funds of the authority. And I so move.
Motion moved is for the consideration of the House. There be no consideration. I put the question. Those in favor say aye. Those against say no. The ayes have it. The motion is carried. The next proposed amendment on clause 5.
Thank you, Mr. Speaker. Mr. Speaker, amendment proposed. Add the following new paragraphs. Approve policies and guidelines for the award of scholarships. I so move.
Motion moved is for the consideration of the House. Honorable members, proceed to put the question. These are matters that they've been consensus, so we don't need to re-debate these matters. Those in favor of the proposed amendment say aye. Those against say no. Honorable members, the ayes have it. The motion is carried. We take the last proposed amendment, which is Roman 9.
Thank you, Mr. Speaker. Mr. Speaker, amendment proposed. Add the following new paragraphs. Provide strategic direction for the authority. I so move.
Do you provide direction to or for the authority? Provide strategic direction for the authority or provide strategic direction to the authority. The English masters.
Mr. Speaker, I think it should be to the authority, except that I was to seek clarification on what strategic directions in this context, what it means if the board is to give strategic direction to the authority.
Actually, that's what I learned in English. Yes, honorable member.
Mr. Speaker, I'm not a student of English, but of drafting. Mr. Speaker, I think 4 is more appropriate than the 2.
Well, my consultant here, the draft person says 2 is more preferable. Now you are still a student. You are allowed to contest your master anyway. But the draft person says to the authority.
Mr. Speaker,
because you are directed and asked what to do.
Mr. Speaker, I yield.
Yes, so honorable members, that's further amendment that you delete 4 and insert 2. So the proposed amendment is provide strategic direction to the authority. Those in favor of the proposed amendment say aye. Those against say no. Honorable members, the ayes have it. The amendment is carried. Yes, please.
Right, Honorable Speaker, I seek your guidance on the whole architecture of what the functions of the board is. I say so because I sense in the drafting, giving day-to-day management activity to the board as well. Because when you check the functions of the Director General, the Director General has been given the mandate to lead the day-to-day administration of the agency. But if you check function, that is clause 5A, which states review and consider applications for government scholarships. Right, Honorable Speaker, this seems to me that we are giving the day-to-day administration of the agency to the board. And I would have wished that we would delete the A, that is the clause 5A from it, and allow the board to be given directives rather than going into the day-to-day administration of what the Scholarship Secretariat is supposed to be doing. And so, with your guidance, if the drafters will agree, then we can delete the A from it so that we do not allow the board to now go into the day-to-day administration of the agency? Thank you.
Well, this issue has been discussed many times, but the current rendition means that the work will actually be done by the Director General and the staff. It's a second that you need the board to review it. And though they will not be doing the day-to-day, you have many submissions, and you have many sectors, and you have skills from all over. And so they will have the opportunity to do the day-to-day by compiling everything and then taking a decision that this list is what qualifies to be considered. But what the board will do is to review it. Don't forget, you are here, and definitely the pressure on you on some of these things. There are so many considerations that go into it. And so when you give, and I have confronted a number of people in this country who talk about protocol lists. Protocol list. Now, I challenge any Ghanaian to go to any institution and see whether the technocrats don't have any consideration also involving their interests. If that is the case, what prevents the people who are given the authority to make sure that we are all made better from having a say in those decisions? There's nothing wrong with that. It's just that people are politicized and partisanship has come in, and people are really not analyzing the issues. You've all experienced them, and you've seen it all over. They have the opportunity to decide who to employ and go and see the employment. And so I think that the checks and balances should be there, yes. But the person who has the ultimate responsibility should have the final say. There's nothing wrong with that. And so I think that will not even end it, because after the board has done the revision, it goes further. And that is where we talk about situating the authority, whether it should be under a sector, the Minister of Education, or should go to the Office of Government Machinery. Those are things also, matters that you'll be considering. Yes, let me listen to him. I'll come back to you.
Thank you, Honorable Speaker. Much as I agree with your proposition, I believe that the situations where board members do this kind of work, we look at commissions instead of authorities. Honorable Speaker, if you have a commission where, like Forestry Commission, where board members more or less engage in day-to-day administration of the institution, then your argument with the greatest respect will be, well placed. But with respect, Right Honorable Speaker, where it is an authority where the functions of the board is supposed to be giving direction to management, I find it difficult to believe that reviewing and considering of application will be a duty of a board. But just wanted to bring that to the attention of Right Honorable Speaker. If it were a commission, I would wholly agree with you. But in this case, I just have a small doubt on it. But I'll still defer to your good judgments, Right Honorable Speaker.
You formulate the policies and they implement. Now, when they do their work, at least there should be the opportunity for you to look at it to see whether it's in line with the policy. And so I agree with you that things like consider applications are not part of review, because those things have already been done by the day-to-day administrators. They have considered the applications, they've gone through them, and they've brought the short lists. And this application will come from multilaterals, they will come from bilaterals, they will come from charity organizations, they will come from various sectors, and you will consider those applications. And being guided by the policy, you now compile. And so at least there's nothing wrong with those who have formulated the policies to look at it again to see whether they are in line with the policies that they formulated, and whether you are going to even the law, you are going in accordance with the law. I don't think there's anything wrong with that one. And so if it is for us to remove the word consider applications, that one I'll agree with you, but to review that this, and I think is right. Yes, First Deputy Speaker.
Right Honorable Speaker, day-to-day activity is completely different from review activity. Honorable Speaker, review activity is a secondary activity. There must be a primary activity leading to the review activity. Therefore, the review cannot amount to day-to-day activity. Right Honorable Speaker, if you look at this particular law, there is a guideline, there's a policy that must be followed by the Chief Executive in receiving the applications and determining whoever is qualified. If the board does not review the applications received and determined by the Chief Executive, how would they be able to determine whether the Chief Executive has complied with the rules and regulations and the policies governing the award of scholarship? So the board, in reviewing the policy, must give consideration to those applications being reviewed. So, Right Honorable Speaker, there is nothing wrong with the rendition. Right Honorable Speaker, I state again that review is a secondary process. The primary process is the day-to-day activity. He has the rudiment of the game to receive the applications, sieve the applications, determine those who are qualified and those who are not qualified in line with the guidelines, the policy. We don't want to leave it like that, where there will be a room for a rumor of corruption. That somebody is not qualified, you have taken something and you qualified the person. That is why it's being subjected to another layer at the board level, where the board will have the opportunity to review the applications emanating from the Chief Executive. So it is the work of the Chief Executive that will be reviewed by the board.
Yes, that's why I say the word consider is primary, and that should not be included. But for review is secondary. Yes, please.
Mr. Speaker, I think that the sponsors of this bill had a certain intention, and that can be deciphered from Clause 10 of the bill. And if you read Clause 10 of the bill, it contemplates the establishment of committees within the board, comprised of members of the board and non-members of the board. And of interest, Mr. Speaker, is the selection or assessment committee. There is a provision under 10.4 which says that the following committees may be formed or established: the assessment committee, monitoring and evaluation committee, and the finance committee. Mr. Speaker, I think that with section clause 10 and reading it in conjunction with the clause 5, which provides the function of the board, there's that intention that the board may be engaged, because that work of selection and assessment is not left to the chief executive officer to determine. There is a board constituted for the purposes of determining whether or not applicants have qualified. And that decision of the subcommittee will come back to the board. That decision of the subcommittee is a subcommittee of the board. It's not a subcommittee of any institution. And if you read it, it is clearly stating that the board may establish committees consisting of members of the board or non-members or both to perform a function of the board. So it's a committee of the board.
Yes, Honorable Member, in practice, you know, it's just to make the work of the board easier at board meetings. So you always have the Chief Executive Officer, the Director General, and the staff do the actual day-to-day work before they send it to that subcommittee of the board or the authority. And that will go through it. Once the subcommittee gives no objection, accepts it, it becomes easier for the board, because there's a lot of work for both the authority, the commission, the board to do. And so that doesn't mean that the board itself is involved at what they do at that level. You see, and I think that those of you who have worked in these things, you experience it on a daily basis. We process a lot of applications here in Parliament. The Parliamentary Service work on a lot of applications. When you ask for employment, you can receive thousands of applications. That cannot be done by a committee of the board. The daily consideration will be done by the technical staff. Then they will shortlist it, and then the subcommittee of the board will look at it. When they look at it and okay it, it becomes easier. Because when the matters come to the board, there are many items. This will just be one of them. And so they easily accept what comes from that subcommittee. But definitely that review is necessary for the board. I think so. Honorable members, you take the decisions, but that is not here. I think you are just asking for my guidance. So let me put the question on the whole of clause 5. And honorable members, the question is that, sorry? There's a further amendment to clause 5. Where is it?
The amendment proposed is to delete C of 5 in the light of the discussion that has just transpired. Administer the scholarship secretariat.
Administer?
Because it's administration.
Where is it?
It's C. 5C. Administer government scholarship. And because we are saying that administrative work are purely supposed to be, if we take it out, it will not spoil anything, Mr. Speaker. I am arguing that...
Yes, I hear you.
Okay.
But who is administering what you're talking about? Is it the authority or the board? No. That should be for the authority, that's the secretariat. So, honorable members, it's not on the order paper, but there's a further proposed amendment for us to delete clause C. Those in favor say aye. Those against say no. The ayes have it. The amendment is carried. I put the question on the whole of clause 5, and the question is that clause 5 as variously amended stands part of the bill. Those in favor say aye. Those against say no. Honorable members, the ayes have it. Clause 5 as variously amended is ordered to stand part of the bill. We've come to the end of the consideration of the Ghana Scholarships Authority Bill 2025. Yes, please.
Speaker, we have to reconsider the long title. Speaker, this House for a long time.
Did you say reconsider?
We have to take a look at the long title.
We have to do the long title?
Yes.
Yes.
So,
but if you say reconsider, it means
yes. So I rephrase, Mr. Speaker.
Yes.
Mr. Speaker, okay. Mr. Speaker, may I seek your leave that, let me wait. When you mention the long title, then I come in. Yes.
Honorable members, what he did is just to remind me that we haven't considered the long title. So let me now put the question. Honorable members, long title of the bill.
An act to establish the Ghana Scholarships Authority to regulate the administration and award of government scholarships in a transparent and equitable manner and for related matters.
Yes. Majority Chief Whip.
Speaker, humbly, my humble position is that we do not legislate for any other country. We legislate for Ghana. So the Ghana in the title is needless. So it should be Scholarships Authority Act, bill in this case, so that we take away Ghana. Speaker.
So we will take away Ghana from education service. Is that a situation?
Mr. Speaker.
From revenue authority.
Speaker, I raised this matter about 8 years ago on this floor.
So everything coming now, we should take away Ghana.
Mr. Speaker, the venerable chairman told me, because I reference other legislation that we've used Ghana. Then so we've moved away from those early colonial days of legislation. And that once we do not legislate for any other country, it is needless to introduce the name of the country into the title of enactments that this House considers and passes. So for a long time, I haven't seen Ghana featuring in the law, all the laws that we enacted, except the Ghana Gold Board. So, no, except the Ghana Gold Board. And the difference was that, oh, please. Yes, I resisted on this floor.
Actually,
so I made the point that...
No, honorable member, you are overruled. We have always been passing laws with Ghana, because in the case of scholarships, there are other scholarship schemes.
Oh, please don't say that.
Yes. There are other scholarship schemes. So you want to be specific. You are doing Ghana.
Well, for the records, I humbly is of the view that I'm of the view that Ghana in the long title is surplusage. It doesn't serve any purpose. But if the House is of a contrary opinion, well, let the record bear me out, Mr. Speaker. I thank you for the opportunity.
Yes, please.
Mr. Speaker, I think the Majority Chief Whip, 9th Parliament, we've passed similar laws with the Ghana being part of it. The popular Mahama Care, the Ghana, we did it, the Ghana Road Fund, Trust Fund. All Ghana have been, I don't know why. So if you are abandoning it, do the right thing.
Now, honorable member, when you go to Google, and then you are now reading and you say Scholarships Authority Act 2025. Do you know the number of this now pop up? So is it Ghana? Is it this? But when specifically you put it Ghana Scholarships Authority Act 2025, that's what will pop up. But if you just say Scholarships Authority Act 2025, a number will pop up, and now you have to go through all to know which one is for Ghana. There's good reason why you have to be specific.
Mr. Speaker, I recall very well what the then majority leader said. He said,
well, we are talking about today's majority leaders.
I agree with you, Mr. Speaker, but the point was
May
that...
we go on? Honorable.
Mr. Speaker, the point was that if we were minded that we could do national instead of Ghana, Oh, so, Mr. Speaker, we learn every day, so I'm guided.
I'm even saying that we have not yet formed a nation. You've heard me say many times we have not yet formed a nation. When we are able to form a nation and we are using national, accept it. Because merit is not what is happening. It's not meritocracy. When you form a nation, the main consideration is merit. Now you are still living in kingdoms, you are still living in regions, you are still living in ethnic groups, you are still living in your religious minds. We have to do away with all that to form a nation. And then we have one vision. And then we are moving. Aspects are being implemented according to the perspectives, not what we are having now. And I've been supported by this with our father, Otunfo, and other great chiefs have stated this. And the intellectuals have also supported that we still have to work towards at least consolidating and entrenching nationhood in this country.
Mr. Speaker, indeed, that is why we must begin to give the nomenclature to our legislations with nation as an attempt to consolidate our coming together.
Oh, but it won't be only Ghana that will form a nation. There are other nations.
Yes.
So you cannot just use nation. It will affect to all, or to refer to all the other nations too.
Speaker, we have the
Honourable member, you are completely out of order.
Thank you.
Honourable members, let me put the question. And the question is that where were we? The long title stands part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. The long title is ordered to stand part of the bill. Honourable members, I can now safely say we've come to the end of the consideration stage of the Ghana Scholarships Authority Bill 2025. Honourable members, yes, leadership. If not, I'll proceed to adjourn the sitting.
Speaker, we've done more than 5 hours. We have a plethora of questions unanswered as well as statements advertised. So may we direct that they be re-advertised for Tuesday so that we can expressly deal with them. I'm sure today the sense of the House is that. Sorry?
Honourable members.
Yeah.
First Deputy Speaker to take the chair.
Okay.
Yes, Majority Chief Whip.
Mr. Speaker, we were making the point that we've done more than 5 hours. But clear indications are that we have plethora of questions unanswered as well as statements advertised for today. But given the sense of the House, today being Friday as well, we are in your hands, but we want to give indication to the table office that the questions that have not been answered today, as well as the statements advertised to have been taken today, be posted to next week, Tuesday. Fortuitously, the Deputy Minister for Energy is here. So he is on notice to return on Tuesday to take these questions, in addition to those that have been stated in the business statement to have been taken on Tuesday. Tuesday will be quite a heavy day, but we'll be able to deal with it. So, Mr. Speaker.
Yes, Honourable Member, you have a legitimate concern. But regarding the questions to be answered on Tuesday, I will leave it to the table office. Because what we are trying to do now is to avoid a situation where the questions will be slated and it is not convenient for the minister in question. So they know the ministers that they have communicated to come and answer questions on Tuesday. So they should communicate to the ministers who are to answer questions today that they couldn't make it. If they can be available on Tuesday, then they will schedule accordingly for the questions to be answered. Secondly, we haven't done 5 hours. Then there must be a motion for an adjournment. But before then, let me make this announcement. Invitation to attend a 3-day training program for leadership of parliamentary committees under the auspices of the Right Honourable Speaker of Parliament, Alban Sumana Kingsford Bagbin, and the leadership of the House. The Parliamentary Training Institute, PTI, is organizing a 3-day capacity building training program for the leadership of parliamentary committees on the theme Strengthening Committee Leadership for Effective Parliamentary Oversight and Governance. Date, Saturday 8th to Monday 10th November 2025. Venue, Aliza Hotel, Ridge, Accra. Reporting date, Friday 7th November 2025. Time, 9 a.m. to 4 p.m. daily. The training aims to improve the leadership and strategic management skills of parliamentary committee leadership, to increase the effectiveness of parliamentary oversight, committee, coordination, and operations, and to ensure the proper application of the rules within committees. Honourable members, thank you for your rapt attention. Yes?
Speaker, on the small matter of notice, the Deputy Minister for Energy, the questions they stand in the name of the Minister of Energy. So he's detailed the Deputy to be here, and the Deputy is here, is a member. So we want to plead with you that there's no need for the House to write again to the Minister on Tuesday, to appear on Tuesday. So we want him to be put on notice that on Tuesday he should return to take the questions. That's all that I'm saying.
Very well.
Because it's available.
Very well.
Because it's available. Don't litigate this.
So the Deputy is assuring us that the Minister will be available to provide answers to those questions, or he himself will be available to do it. Yes.
Mr. Speaker, may I, this having been said, may I move?
Well, let me listen to the minority, Deputy Minority Whip.
Matter.
Then you can have the floor to move the motion. Yes,
Speaker. Yes. I think that my colleague on the other side, who is becoming Kilantia, should engage. Kilantia means that killer is not paying. Should engage. You can't just be doing this without recourse to us and act as if that is consensus building. Mr. Speaker, we are minded to take the Deputy Minister. We haven't done 5 hours. We are willing to sit.
Mr. Speaker, Mr. Speaker, the part that I disagree with that he cannot say that the minister responsible for energy should answer his questions on Tuesday. Today, the majority leader and the chairman of the business committee presented the business committee report to us. We adopted it of which the Tuesday was not part of it. Mr. Speaker, at conclave, you were there with me, and we did not have any indication that the Deputy Minister is coming to answer the questions. We got a different indication from the majority leader. He communicated to us what happened to the minister, and the minister cannot answer the question at conclave. We agree that with the Speaker, but we cannot say because the minister being unavailable today, we are programming him for Tuesday. That is not how it is being done, because we have business already programmed for Tuesday, and for that matter, you cannot hijack and say that should be put on Tuesday. So, Mr. Speaker, that one there, they left with the business committee to program such question, not the majority chief whip.
Mr. Speaker, my brother Habib should come down. All we are saying is that we ought to have taken 9 questions today, plus 4 statements. But given the exigencies of the House, we are unable to. And today is Friday, and the minister has detailed his deputy, able deputy, who is capable to respond to the questions. But it is the sense of the House that we cannot take those answers. So it is the practice. I mean, when you were here, we were offloading business to, we were doing that. So, Speaker, all I'm saying is that if he will not oppose the request, then we should push today's questions and statements to Tuesday to be accommodated alongside businesses slated for Tuesday. That's all I'm saying. So if Tuesday
members,
business
we
is
can
too much,
continue this way.
Yes.
It's almost 8 o'clock. So the indication that we are ready to do business, I don't believe it to be true that we are ready to do business. So, Honorable Majority Chief Whip, may you do the needful.
Speaker, there be no further business to be conducted. I move that this House be adjourned until Tuesday, 2 p.m. I so move, Mr. Speaker.
Honourable members, motion is moved for adjournment.
Mr. Speaker, we are not opposed.
And it is for the consideration of the House.
Mr. Speaker, we are not opposed.
Honourable members, motion moved.